Judge
Oh,
Manning,
yes, ma'am.
I wanted to let you know that Robert Cazzoli is running a little bit late. He got held up at the jail, but he is going to be here ASAP.
Okay. All right. Thanks.
You're welcome.
All right. Let's see. We'll go ahead. Is Miss Lubinsky, who, yeah, she's here. Okay. So we'll start, Miss Lubinsky. We're going to start with Mr. Davenport since he's in medical. We know they're trying to shuffle things around. Okay.
Thank you, Your Honor. Now,
All right.
Your Honor,
Yes, ma'am.
with Mr. Davenport, there is something I need to tell the court and the ADA that I would prefer to remain confidential. Would it be possible to do that in a breakout room?
Sure. Let's see. Hold on. Let me create some breakout rooms really quickly. All right. Which ADA is going to handle the Davenport case?
I'm sorry, ADA Audrey Simmons.
Okay. So I'll move you into breakout room 1. It's Lubinsky, and I'll join in. We can take care of this really quickly.
And Your Honor, Mr. Davenport's mom is also on. I don't know whether you want her in the breakout room or not.
Nah, this is BS. All right, there you go. Y'all go ahead and join. I'm coming right now. All right, everybody, we will start with Mr. Davenport. Bostic, it's position 1 on one of the calendars. Hopefully that helps you. All right, it's 22 CP 210205, 214 days without indictment. Malik Davenport, armed robbery, aggravated assault with intent to rob, possession of a knife or a firearm during the commission of or attempt to commit certain felonies. There's a $110,000 bond as of June the 28th of 2022. Pre-trial.
No prior arrest.
All right. Go ahead, Ms. Lubinsky.
Thank you, Your Honor. And Your Honor, Mr. Davenport is 17 years of age. He has been in jail 214 days without indictment and without even a preliminary hearing. Your Honor, he has no prior criminal history. He lives with his parents in Rex, Georgia. And Your Honor, I can give you the full address. 6745 Oakley Court, Rex, Georgia. He lives with his mother, Monica Davenport, and his father and his sister. His mother, Monica, and his sister are present on the Zoom hearing. Your Honor, at the time of his arrest, he was going into 11th grade at Mount Zion High School. Your Honor, since he has been in jail, he has been assaulted and he has been stabbed 4 or 5 times. He's been hospitalized once. That's why he's actually in medical at the moment. The charges themselves are an allegation of armed robbery, but there is, from what I can make out, no corroboration for the young man's version of events. No firearm was ever found. No stolen items were ever found. There's a reference to the person who committed this offense driving a particular vehicle. Again, no evidence that this young man actually drives that particular vehicle. So he has literally been in jail now for 214 days without indictment, without a preliminary hearing, based on the based on a statement made by the complaining witness. And he suffered some extraordinarily bad assaults while in the system. He has a bond of $110,000, which he cannot possibly make. I would ask the court to consider reducing it to perhaps somewhere in the region of a total of $20,000, in the hope that his parents may be able to make that bond. Conditions would remain that he be on an ankle monitor, and, Your Honor, that he attend, that he have a 24-hour curfew if necessary, with the only exceptions being for school, work, medical, or legal. Your Honor, he is not a risk to the community. He is not a risk of flight. He is not a risk of intimidating witnesses, and he has extremely close ties to the community. Is there anything further on which the court would like to hear me?
No, that's okay. That's good. Booth 5 South. 5 South, booth 2. 5 South, booth 2. Is that microphone, is that not working there? Can he not hear? 5 South, booth 2. I need to see if that's working.
Yeah, now let me see if I can get in contact with the deputy on the floor.
Okay, I don't know if it's working. But gentlemen, if y'all just stay in your seats, please, okay? Because if you get up and walk out and I call your case, it'll be reset because you're not there. And then, of course, don't sit with your back to me like that, okay? What says the state? Ms. Simmons?
Well,
Myself. Yes, good evening, Judge.
Good evening.
Before I start, I was informed that the mother of the victim is on the Zoom, and
Okay,
I do believe that she at some point would like to address the court.
okay, is her name also, last name Howell? Or what's her last name?
Let me just check, Judge. Oh,
And Judge, there are several people without their name displayed waiting to get in, so I'm not sure if this is.
Yeah,
yes,
we don't,
Judge. I don't see her. I don't see
Okay.
her name displayed.
what's her first name? Do you know her first name?
I'm trying to find it, Judge, in my notes.
Okay. Yeah, 'cause
I can help perhaps.
Thank you.
According to the incident report, her name is Sandria.
So there's a 910 area code, but we don't let them in if we don't see their name. You know, we could have some people in here that don't need to be in here. So I don't see her on there. But go ahead, Miss Simmons. We'll see if she'll answer because Miss Robinson keeps sending messages there telling them that their screen name has to be their name and not their phone number or just their initials or something crazy. So go ahead, Miss Simmons.
Yes,
And I'm
Judge,
sure maybe Miss Ferreira could tell us what if she spoke with her.
Stand by, Your Honor.
Okay.
Full North, booth 3. I need one person who's supposed to be in court sitting down. Full North, booth 3. If you got a court case, have a seat.
Shut the door. There you go. Nope, we're not. Both of us ain't getting in there. Get the other one out. Other guy needs to get out. 4 North, booth 3. The other person needs to get out while you're in there till I call his name.
Lord. If you got a court case, stand by till that first person gets done. When they're done, then you come back in.
All right, go ahead, Miss Simmons. We'll see if the mom gets on.
Yes, Judge. Our Judge, in light of the fact that the court did grant a bond of 110,000, as Ms. Lubinsky has said, so this is actually a motion for reconsideration of bond. And in listening to what Ms. Lubinsky has said, I'm not sure that there has been advanced enough material change in circumstances that would warrant the court undoing the decision of the previous court in terms of the bond that was granted, and that was based on the seriousness of the offense and of the allegations against the defendant. And I'm aware of what Ms. Lubinsky said in terms of what has happened to the defendant while he has been in custody. And so, Judge, the state at this point does not have any objection to a reduction in bond so as to allow his parents to try and make the bond, but we would require the 24-hour curfew, anchor monitoring, and complete stay away from the victim and from the incident location.
All right, you want to give me some numbers?
I think a bond of 75,000 would be appropriate, Judge.
You want to break that down? How you want it?
Logging off and logging back in.
I'm sorry, Judge. 35,000 for the count 1, 20,000 for count 2, and 10,000 and 20,000 for the possession of the firearm, count 3.
Okay.
Your Honor, may I respond?
Okay, yeah, quickly, because I got a huge calendar. Go ahead.
I get that, Your Honor. 75,000 is way beyond the means of these people. These are merely allegations. And this young man has suffered incredible harm based on these allegations, as yet untested in any forum. It is literally unconscionable and unconstitutional to keep somebody in jail for this period of time without an indictment and a bond he cannot make. Please, Your Honor, something within the reach of the family.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 5 Cleveland Avenue Southeast. Also, sir, you need to stay out of Fulton County. Mom, Dad, you're on here. The only reason you come to Fulton County is court or to see his lawyer. So y'all need to fill up with gas in Clayton, drive him to the courthouse, go back, don't run out of gas, don't get a flat tire, don't even stop at the drive-thru and get lunch, Chick-fil-A or anywhere else, okay? No further contact with Timari, last name Howell, Howell. Gonna have an ankle monitor paid for by the Orca Project, court, lawyer, medical. Ms. Lubinsky, has he graduated or is he going to get back into school?
No, the plan would be for him to go back into school, either in person or online, depending what we can manage.
Okay, school and or employment, but he has to provide proof of being enrolled in school, proof of employment, name of his employer, a schedule, and the exact location he'd be working. He'd have to do the same thing, proof of the school he's in and what his schedule is. This doesn't mean he does anything outside of go to school, come home, go to work, come home, medical and things of that nature. So stay out of Fulton County, sir. That curfew is 24 hours a day. I'll do 20, 20, and 10. So it'll be a total of 50,000. Look, I made those numbers easy. 20, 20, and 10. Best of luck to you, sir. Thank you, Mom and Dad.
Thank you, Your Honor.
Thank you so much, Your Honor.
Thank you.
That concludes my business. May I be excused?
Yes, ma'am.
Thank
Thank
you, Your Honor.
All right. Do I have Alfonso Yusti? Wave your hand. All right. Are you Alfonso Yusti? What's his other name? What's his AKA?
Artist Powell.
Artist Powell. Nope, not answering to that either. Okay, what about?
Judge, wait a minute, she's coming.
Okay,
I'm sorry. Your Honor, that subject's in Cobb County.
okay. Is this Patrick Williams? Okay, Mr. Tessier.
Yes, Judge.
All right, there's your client. You want to tell him really quickly? Patrick Williams.
Williams, they've indicted the case, so the judge won't be able to hear a bond tonight. You could give me a call tomorrow after 3 p.m. and I could tell you more.
I think that means okay.
Yeah.
All right, now, Cobb, do we have Mr. Alfonso Yusti? Or
See.
is that your only 2 cases? Oh no, you got a couple more. Is this him, Mr. Houston?
Yes, Sean.
Okay. All right. It's position 10 on one of the counters, Bostic. 22 CP 213092, Alfonso Yusti, Eutsey. I hope I'm pronouncing that correct. If I'm not, I apologize, sir. 109 days without indictment, aggravated assault, obstruction of law enforcement officer by use of threats of violence, disorderly conduct. There's a $26,000 good bond as of October the 11th. Pre-trial.
In regards to Mr. Yusti, 12 prior arrests, total 3 convictions for misdemeanor, burglary conviction in the 90s, 1 arrest for probation violation. Nothing further.
All right, go ahead, Mr. Houston.
Yes, Your Honor. Mr. Artist, or Mr. Powell is 52 years of age. He is residentially challenged. He does have a high school diploma out of Massachusetts, currently unemployed. Do have some mental health issues. In terms of bond, Your Honor, he's not from what I can hear from pretrial, he's not a convicted felon. I understand he does have misdemeanor. Well, he doesn't have any prior convictions for felonies within the last 10 years. Does have misdemeanors, only 12 cycles. In terms of the aggravated assault, we would ask for a bond of $10,000. Disorderly conduct, we would ask for UJR, and for the willful obstruction, we would ask for a bond of $2,500.
All right, what says the state?
Yes, Your Honor. With regard to Mr. Eutsey, the $26,000 good bond, Your Honor, I do believe was a fair and reasonable bond in all the circumstances. The allegation is that he attacked the victim with a knife and inflicted several wounds on the victim, and also resisted law enforcement's commands to drop his knife. And Your Honor, in his attorney's recitation, I don't hear anything that amounts to a material change in circumstances which would warrant a modification of this bond in terms of reducing it. Nothing has changed. The allegations are still the same. He does have a bond that the court, in its wisdom, imposed in all the circumstances, and there has been nothing put forward which would warrant a change in the bond at this time. So the state will be opposed to a reduction in bond.
Now, Mr. Houston, is he going to live in Fulton County?
Yes, Your Honor.
So sir, you going to live in Fulton County? Thumbs up or thumbs down? Mr. Alfonso, are you going to live in Fulton County? Can you give me a thumbs up or something? Or nod your head or shake your head. You got to do something so I can see you. Okay, he's just sitting there. Mr. Alfonso, can you hear me? You can't hear. Or he's talking. You're muted, sir. That's why I need you to give me a... Yeah. Mr. Alfonso, can you hear everything that we said?
That's not my name. My name is Otis Powell.
Okay, well, you got an alias. Anyway, did you hear everything we said?
That's not my alias. That's my real name.
Sir, did you hear everything we said?
Yes.
All right. Are you going to live in Fulton County?
As a homeless person, yes.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Courtney Spells. Stay away from 48 MLK Junior Drive. No further contact with Officer E. Hall, Investigator Chris Davison, Davison, unless in their official capacity. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and work as long as you provide name of your employer, proof of employment, location, and a schedule. You have to supply that to the ankle monitoring company and to your lawyer so they can supply it to the state. 15 on count 1, 3,000 on count 2, and 500 on count 3. 15,000, 3,000, and 500. Best of luck to you, sir. You can leave the booth. That's it for Cobb, right?
Yes, Judge.
Yes, Your Honor.
Thank you, Cobb.
Judge Manning, that concludes my business. May I be excused?
Yes, sir. Thank you.
Ma'am.
So ACDC, who do we have up there?
Position number 2,
What's your name, ma'am?
Gabrielle Williams.
Okay, that's what I got. All right, Gabrielle Williams is position 2, Bostic 22 CP 211284, 173 days without indictment. There's a $7,000 good bond as of August the 8th for willful obstruction of law enforcement officers, felony, and simple battery. Free. Rah.
Honor, few arrests, no felony convictions, 2022 conviction, theft of services. Nothing further.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. Ms. Williams has now been in custody for, I believe, over 200 days at this point. She is 28 years old and a lifelong resident of Georgia. She did grow up in Cobb County and attended Rocky Mountain Elementary School and then last at her high school. Her whole family is here in Georgia, which includes her father, James Williams, and her sister as well. We are currently seeking options for Ms. Williams in regarding MH treatment and housing. But at this time, Your Honor, her bond is higher than any programs we partner with would be able to provide assistance for. Given that Ms. Williams has now been in custody for such a long time and she's already had her preliminary hearing and this case remains unindicted, I'm asking the court to consider a reduction in bond so that way we would be able to put Ms. Williams in those in a program once we find the appropriate placement for her, for which I would be submitting a transport or release order once we have a valid address for her. Thank you, Your Honor.
All right, what says the state?
Your Honor, again, there's no material change in circumstances. All the circumstances that defense counsel articulated were in place when the bond was set. And upon review of the warrant, the defendant assaulted a police officer, charging at the officer when she was instructed to leave the incident location. In the event that the court does decide to lower the bond, the state would request that the defendant be required to wear an ankle monitor at the county expense and to stay away from the incident location.
All right. So, no drugs unless prescribed, no alcohol, no weapons. Stay away from 165 Cortlandt Street Northeast. Stay away from the Sheraton in the city of Atlanta. No further contact with Shanika, Chanica. Desmangles.
I believe that's the officer, Your Honor.
Yeah, unless, well, I was gonna say, unless in the official capacity. DESMANGLE. Ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, MH treatment, or addiction treatment, and employment. As long as you provide proof of employment, name of your employer, schedule, and the exact location you'll be working, you have to provide that to the ankle monitoring company and to your lawyer. And you have to provide an address where you're going to be living. So if she gets you into a program, man, that gives you housing, you provide the address where you're living to the jail upon release. So I will reduce this a little bit to 4,000 and 1,000.
Thank you, Your Honor.
Bill Project can help you. Thank you, ma'am. Need O.C. May Williams. And I think Mr. Cazzoli got here. But there he is. All right, it's position 7, Bostic, on one of the calendar, sorry. O.C. May Williams, 22, CP 206303. 359 days without indictment. We got criminal attempt to commit robbery and battery. As of April the 26th, there is a $9,000 good bond.
Judge Osimay Williams, multi-state offender, 15 California, 12 Tennessee, 4 New York. Has a hold for FTA. 4 arrests in Georgia, 1 misdemeanor, prior convictions, force with deadly weapons and narcotics in 2019. Nothing further.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor. Good evening. Thank you for your patience in letting me get here. Ms. Williams is now 57 years old. She still has a good address at 150 10th Street, Atlanta, Georgia, where she lived for about a year before her arrest. Your Honor, there are some underlying MH issues here. Your Honor, 1 week from today will have been a full year in custody for an unindicted case. She had a preliminary hearing back in August. So we're talking about now 5 months post preliminary hearing where she's still being held without indictment. Her bond was originally set almost a year ago at $10,000. I believe it was Your Honor that lowered it to $9,000 a couple months after her arrest, and it has been held at $9,000, which she cannot afford ever since then. Her bond modification was denied after her preliminary hearing. So today, Your Honor, we are asking for that bond to be reduced to something she can afford. I heard from Madam Pretrial that there is a hold. We would ask that the court grant a UJR to that hold with a condition to being for that hold being picked up, and if not, a $5,000 bond that the Bail Project would be able to assist her with. As mentioned, there are underlying MH issues. We have had a social worker involved, Your Honor, but again, this is going to be, we're nearing a year without an indictment. And there's, the state had their opportunity to find probable cause in August, and there's still been no indictment. So we're asking for some movement here.
All right. What says the state?
Your Honor, the victim in this case has been contacted and is against the court reducing the bond. And Your Honor, in denying the bond motion, the court said that the defendant had a significant likelihood to reoffend and poses a significant danger to the community and to the victim. I think her extensive criminal history tends to indicate that she does pose a significant risk to reoffend. And there has been nothing advanced other than she can't make the bond to the court to justify a reduction in the bond. That is not a material change of circumstances, which would give the court the basis upon which to reduce this bond. And on that basis, Judge, the state is opposed to the reduction in the bond and believes that the bond order as granted should remain in place.
So, Mr. Cazzoli, the 150 10th Street, the victim lived there for the, so I had placed before that she stay away from there except one time return with law enforcement to collect her belongings.
Yes, Your Honor. I understand that. We will continue to look for some kind of housing, and I would understand if the court was not inclined to grant the UJR for that reason. But I believe that, as has been brought to the court's attention previously, a permanent address is required for the bail project services, Your Honor. So a $5,000 bond wouldn't just be releasing Miss Williams to the street. There would still be that requirement of finding some kind of permanent housing that she can provide for the bail project. And as to what ADA Simmons said, Your Honor, the material circumstances that have changed are the continuous dangerous situation that the jails, all of these jails, are in, Your Honor, and the fact that there has been no reduction and no attempt to indict in almost a year at this point.
All right. No drugs unless prescribed, no alcohol, no weapons. Ma'am, you have to stay away from 150 10th Street Northeast. I'll leave it where you can return one time with law enforcement to retrieve your personal belongings if they're still there. I understand how long it's been. You're going to be an ankle monitor supplied by the county, by the Orca project, by the county with a 24-hour curfew, court, medical, attorney visits, and employment, as long as you supply the name of your employer, proof of employment, the schedule, and the exact location you'll be working. I understand you have a hold, so ma'am, you'll have 48 hours to get back and have that ankle monitor placed on your ankle, or else they'll issue a warrant for your arrest. 2 North, sit down, stay in your chair. Leave one more time, and your case is going to be continued. You understand? All right, back to you, ma'am. So you have 48 hours to get that put on. No further contact with James Green. And you'll need to supply an address where you'll be living, okay? So if the bail project does get this for you, you'll have to supply an address. You need to supply an address where you'll be living upon bonding out. So I'll change it to $3,000 and $2,000, $5,000 total. Best of luck to you, ma'am. All right, do we have Miss Brown? Is it Kendall Brown? South Annex?
No, ma'am, I don't have a Brown.
Who else you have?
I have a Mr. Walker.
Who?
That's a Mr. Brown, Your Honor. Mr. Brown is my client.
All right, so who do you have there, South Annex?
Walker, Takia Walker.
That's my client.
Okay. I don't know why it was in a different order. Okay.
She's on the add-on.
Oh, yeah, I got you. Okay. Oh, just on my rotation list. Usually all the South at ACDCs together. All right, Miss Walker, you got 2 cases here. It's one of the add-on counters, Bosick 22 CP 208717, 270 days without indictment, $20,500 good bond as of July the 5th. Possession of Schedule 2 controlled substance, loitering and prowling, possession of drug-related objects. 22 CP 209921. Same thing, 270 days. Aggravated battery, there's a $10,000 good bond as of August the 16th. Pre-trial.
It's the add-on with 4 positions. Takia
so.
Walker.
Yes, ma'am.
14 prior arrests. Took a PTI on theft by shopliftings. Don't appear to have any felonies, 4 misdemeanors. Battery, family violence, 2 counts in 2011. A few FTAs. Last one been in 2011. A couple of arrests for probation violation. Nothing further.
All right. Ms. Bray, you handling both of them?
Yes, Your Honor.
All right, go ahead, Ms. Bray.
Okay, so Miss Walker is 43 years old, Your Honor. She has lived, she's a lifelong resident of Atlanta, Georgia. We have an address. You may have received it the last time she came before for a bond hearing, 3832 Adamsville Drive, Southwest Atlanta, Georgia, 30331, where she has lived for the last 4 years. She is the mother of a daughter, an adult daughter, and she has obtained her GED, and she was working at the gas station where this allegedly, well, where everything happened, Your Honor. She was actually working there. I am asking Your Honor to take into account 270 days in, unindicted. We did the prelim on this case back in October. And no decision has been made. So I am asking Your Honor to reduce the bond to 5 so that maybe I can go through the bail bond project.
All right, what says the state?
On which-
5 South, booth 2. Sit down. Gentlemen, I promise you, there is nothing going on behind you that's more important than sitting here and paying attention to me. If I call your case and you are not sitting in your seat, it will be reset to the end of the month. Y'all are grown men, gentlemen. Light somewhere, like my grandma used to say. Go ahead. What says the state?
Yes, Judge. In which case is the defense counsel asking for a reduction to 5,000?
Probably all of them.
Yes, all of them. You know me well.
If I know Miss Bray.
Yes, Judge. With respect to 22 CP 208717, which is the possession of a Schedule II controlled substance charge, the state would have no objection to a reduction in this bond to 15,000, Your Honor.
Okay.
And with respect to the aggravated battery charge in 22 CP 209921, Your Honor, the state would object to a reduction of the bond in this case. As pretrial has indicated, the defendant does have a history of failure to appear, probation violations, and while there are no felonies, a lot of the misdemeanor convictions are for violence, fighting, those kinds of offenses. And with respect to the allegation, Your Honor, looking at the warrant, the alleged attack on the victim in this case was totally unprovoked. The defendant struck the victim, and while she was on the ground, she kicked her around the face, resulting in a fractured eye socket and a fractured jaw, which the victim still continues to have difficulty with since this incident, Your Honor, in terms of pain, and she continues to suffer as a result of this alleged unprovoked attack. And so for that reason, Your Honor, the bond that was granted in the case of $10,000, I do believe in all the circumstances, in particular, the unprovoked and violent nature of the attack, I think it's reasonable in all the circumstances. And the state does believe that this defendant does pose a significant risk to the community. As I said, Your Honor, the unprovoked and violent nature of this attack is cause for concern.
Your Honor, it was not an unprovoked attack. My client was maced in the store. This little disagreement started over $5, and it just started over $5. But she was maced before anything happened, and she walked away a couple of times before anything happened. And it was caught on video, and that is the information that came out during the prelim in October 5th. She was maced first, and she had already walked away 2 or 3 times.
All right, on the position ending in 8717. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3657 Martin Luther King Jr. Drive Southwest. I think I already said no drugs, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county or ORCA with a 24-hour curfew, court, medical, attorney visits, and also work. Name of your employer, proof of employment schedule, and the exact location you'll be working. Ma'am, you just have to supply that to the ankle monitoring company and to your lawyer. So I'll reduce count 1 to 8,000. Count 2, I'll leave it $250. Count 3, I'll reduce that to $100. 8,000, $250, and then $100. Position 2. No drugs unless prescribed, no alcohol, no weapons. You got that ankle monitor paid for by the ORCA project with a 24-hour curfew except for work, attorney visits, medical, court, and also you have to, and for some reason on here before, I think you added school if it's requested, if she wanted to go back to school, I think, because I put that down there. So if she does, you can amend that. you can just send me an amendment if she wants to go back to school. But you have to supply the proof of employment, name of your employer, the schedule and the exact location you'll be working, ma'am. And I don't think there's any holds, but I do like to put on there, if there's any holds, you'll have 48 hours to have that ankle monitor placed on your ankle after you're released. I'll reduce that to an $8,000 good bond. Best of luck to you, ma'am. Is that it, ACDC?
I believe I have one more client there, Your Honor.
All right, who's that?
Miss Brooks.
All right. Okay, yes, Shanti, right?
Yes, Your Honor.
All right, that's position 3. It's 22CP209955. Shanti Adele Brooks, 224 days without indictment. There's a $12,000 good bond as of 9/22. And I say 12 because the possession of a firearm, that one count was dismissed. So now she's got his aggravated assault and 224 days. That 12,000 was 9/22. Pre-trial.
Number 3 on that secondary add-on, 5 in Georgia, 1 in Michigan, 4 in Florida. In Florida, she has a prior sale of cocaine. There's a hold out of Hamilton, Ohio, I believe. There's an FTA in 2019. First offender taken on financial transaction card fraud and a prior probation violation. Nothing further.
All right, go ahead, Ms. Correa.
Thank you, Your Honor. Miss Brooks is now 36 years old. She did have a birthday in the jail during the length of her, her lengthy stay within the custody of Fulton County. She has resided in the Metro Atlanta area since 2011. The address that you see reflected on Odyssey is a good address for her, and that is where she would be residing with a friend. However, I'm sure Your Honor has already noticed that the little warrant flag has popped up on Odyssey for what we believe is a DeKalb County probation hold. So regardless of any reduction that you would be willing to grant today, Ms. Brooks would likely be going to the custody of DeKalb County prior to being released on the street. Ms. Brooks does have 3 adult daughters and is the proud grandmother to 1 grandchild. And at the time of her incarceration was working custodial services with some of the churches in the downtown Atlanta area. I do understand what her criminal history is. I also understand what she's being charged with, but at this stage, given the length of her incarceration and that there has been no material change in this prosecution, I am asking Your Honor to consider granting a substantial reduction so that way Ms. Brooks can at least go and handle this hold in DeKalb County, and maybe by the time she has resolved that matter, this case will be indicted and she can handle it. She'd be able to handle these charges here in this jurisdiction. At this time, Your Honor, I would ask for you to consider a $5,000 bond.
Okay, she's going to live at the Maple Drive address?
Yes, Your Honor.
All right. What says the state?
Your Honor, the state is opposed to a reduction in bond in this case. I won't bother to recite the defendant's criminal history, but you can, if you recall, Your Honor, there's a number of failure to appears and also a probation violation. And Your Honor, looking at the warrant, the circumstances of these allegations, the victim was stabbed multiple times in the neck, face, and head by this defendant. And I do believe that she does pose a significant risk to the community and also potentially to the victim if she is really, if her bond is lowered. I do think that the $12,000 bond that she is on is reasonable in all of the circumstances, especially as it relates to her criminal history and the violent nature of the allegations that she's facing.
All right. I see that she's been under 224 days. And so, we got to do something. No drugs unless prescribed, no alcohol, no weapons. You're going to have ankle monitor paid for by the county with a 24-hour curfew, but you have that hold. So you have 48 hours once you're released from DeKalb to contact the ankle monitoring company and have it placed back on your ankle. You'll be able to leave for court, lawyer visits, work, as long as you supply a job title, schedule, submit it to the attorney and the ankle monitoring company, exact location you'll be working, and proof of that employment. I think I already said no drugs, no alcohol, no weapons. I think before may leave for mental health or any kind of addiction treatment. So we'll keep that on there. And no further contact with Lawrence, Lawrenc Johnson, common spelling. Like I said, the possession of a knife or a firearm, which was count 2, was dismissed at a prelim. We're just on the ag assaults. We'll make that an $8,000 good bond. Best of luck to you, ma'am. That's it, ACDC. All right, have a good one. All right, now we got Kendall Brown. Wave your hand if you're Kendall Brown. All right. Position 14, 22 CP 213143. Kendall DeJuan Brown, robbery by sudden snatching. There's a $25,000 good bond as of October the 13th. 107 days without indictment. Pre-trial.
Judge in regards to Brown, multi-state, 3 in North Carolina, 7 in South Carolina, 11 in Georgia. Prior felony theft by shoplifting, misdemeanor larceny, and another theft by shoplifting. Nothing further.
All right, Mr. Cazzoli.
Thank you, Your Honor. Mr. Brown is 36 years old. He's a high school graduate. He was originally from Mississippi, and his arrest took place very briefly into his Georgia residence. He is also residentially challenged. Your Honor, there are some severe substance use issues underlying his history and the facts of this case. His bond is currently set at $25,000. He has no income whatsoever to speak of, so we are asking for a reduction to $10,000. As mentioned, he has been in a little over 100 days without indictment.
All right, what says the state?
And good evening, Your Honor. This is 88 Jordan on behalf of the state for this case. Your Honor, given that the defendant has no previous felony convictions, the state would not oppose the reduction to the $10,000 that was suggested by Attorney Cazzoli.
All right. Ms. Young, make sure you put on there the state consented to the $10,000 good bond. No drugs unless prescribed, no alcohol, no weapons, no further contact with Susan Trejo Garcia, Trejo-Garcia. Stay away from Tequila on Broad, 54 Broad Street, Atlanta, Georgia. That ankle monitor is going to be paid for by the county. You'll be on a 24-hour curfew except for court, lawyer, medical, and employment. Supply the name of your employer, proof of employment schedule, and the exact location you'll be working, sir. You also must provide an address upon getting bonded out. That means when they start to let you out, you have to have an address where you're going to be living. If you work Mr. Cazzoli, maybe he can help you get a place to stay. But you have to provide that. If any holds pop up, you have 48 hours to have that ankle monitor placed on your ankle. Ms. Young, don't forget, state considered $10,000 good bond. Thank you, sir. You can leave the booth.
Yes, ma'am.
Jerry Reynolds. Jerry Reynolds. Oh, I got you. Are you in 2? Is that you in 3 North? All right. Let's see. 22C is position 8. Bostic 22CP 213071. Jerry Reynolds. 111 days without indictment. There is a $60,000 good bond as of October the 10th. Aggravated assault against a law enforcement officer while engaged in their official duty. Willful obstruction, felony, and criminal damage to property, 2nd degree. Pre-trial.
Give me just a second on that one. Let me pull that one up. I can write down my notes. Sorry.
That's okay, Bostic. You clip it about the same time you were this morning. Ain't that right, Miss Sarfaraz?
It must mean he don't have anything. I don't have any notes on my piece of paper.
Yeah, it just says my understanding he doesn't have a criminal history. This was his first arrest.
Yeah. Yeah, no prior arrest. I just put the EMPA on my piece of paper.
Oh, okay. All right. Go ahead, Miss Sarfaraz.
Thank you, Your Honor. Mr. Reynolds, he's 18 years old. He's been in Atlanta the last 3 years. He moved here to be with his father. His father is a truck driver, so I've actually spoken with him several times. He travels a lot. With Mr. Reynolds, he does have some MH issues here. We have some severe diagnosed MH issues where he actually receives SSI for it, Your Honor. We are working on trying to find the most appropriate program for him. We have put in the social worker request already. My understanding is the social worker is actively trying to get him into a program, but as Your Honor knows, it takes some time. sometimes to get people into certain programs. And so, Your Honor, he did have a prelim back in this month. Actually, he just had a prelim on the 19th of this month where a probable cause was found. So we are still going to ask Your Honor if we could reduce the bond today to $30,000 total. That is about half the bond. Mr. Reynolds can't make the current bond as set. He can't even make the $30,000, to be perfectly honest with you, but this just helps us chip away little by little so we can get to a number, or the state can indict his case and move it along. Thank you.
All right. What says the state?
Your Honor, in light of the fact that Mr. Reynolds doesn't have any criminal history, the state would be inclined to consent to a reduction in the bond, but certainly not to a 50% reduction. Looking at the allegations in the warrant, Judge, the officers were attempting to detain the defendant in order to investigate an allegation of damaging motor vehicles. When the officer approached him, he hit the officer in the head in the face with a bottle, which actually shattered on impact, leaving the officer with injuries to his face and his neck and his hands. And so, Your Honor, the nature of the allegations against him would give the state pause in consenting to a 50% reduction. We would defer to the court with respect to a number for the reduction, but certainly the state would oppose a bond of $30,000, a reduction to $30,000.
And Your Honor, the defense's position is that the state is that concerned with Mr. Reynolds. We don't understand why he hasn't been indicted, so he can handle this case through the proper court process.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Sheldon McDonald or D. Coleman unless in their official law enforcement capacity. Stay away from Hilliard Street and Edgewood Avenue. And he's going to live in Fulton County, right? So I got it pulled up over here. So he's still going to live at that same address, which is Guinness Road.
Let me double check, Your Honor.
Mr. Reynolds, you still going to live at Guinness Road? I need a thumbs up or a thumbs down.
Yeah, I don't think that is a good address anymore. His father had provided me a different address in Lawrenceville.
Okay.
But from my understanding, the most appropriate and the best solution for him is the program. So that's why we're trying to get him into that.
All right. But he's going to be in Lawrenceville if he's housed with his dad.
From my understanding, yes, Your Honor.
All right. So if an income order paid for by the county of the 24-hour curfew, court, lawyer, medical, MH, or addiction treatment and work. You have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. You supply it to your lawyer and to the income monitoring company, sir. If you don't supply it to them, they'll violate you for not telling them where you're going to be. Also, since you're going to live in Lawrenceville, you can stay out of Fulton County unless you're here for court, lawyer, or one of the treatment programs that Ms. Safarazzi gets you to. Mr. Reynolds, I hope you're listening. Because you're looking down. Doesn't show me active listening. Stay out of Fulton County, sir. You understand? Don't get gas. Don't get lunch. If you come here, you fill up with gas in Lawrenceville, come to Fulton County and leave. Don't get a flat tire. Don't even think about stopping in Fulton County for anything. All right. I'm going to do 17, 17, and 5. Best of luck to you, sir. You can leave the booth. 17, 17, and 5.
Thank you, Your Honor.
All right. Let's see. Chaz Banks. Got you. Thank you, sir. 22 CP 212-425. 525 days for aggravated assault. As of September the 19th, there is a $25,000 good bond. Pre-trial.
In regards to Mr. Banks, 7 prior arrests, no actual felony convictions, took a first offender on criminal damage to property, 1 misdemeanor, open case 22 CSC 182226, armed robbery, 2 counts, firearm by first offender, I guess, and reckless conduct, 2 counts, signed to Dunaway. Nothing further.
Is that still open, or you said he took his first offender?
Is open.
Oh, okay.
He took first offender on criminal damage to property.
Oh, okay. All right. Go ahead, Mr. Tessier.
Thank you, Judge. Mr. Banks is 23 years old. We do have a good address, 1406 Poplar Point Drive. I confirmed with his mother a couple of days ago. She said he definitely can stay there with her. He's got his father, his mom, and his siblings that live here in Georgia. He's been here his entire life. I believe his mom explained that he does have 1 child. has completed the 10th grade. As you know, Judge, he's been in jail way over a year at this point. This is particularly a newer charge that has been added since he's been incarcerated. He has adamantly maintained his innocence, Judge. We're actually in the process of trying to get video footage to exonerate him on this charge. Judge, I spoke to his mother. His family is very supportive of him. They cannot make this bond. It's far too high. This one alone itself is far too high, let alone the other charges that he has. So we would be requesting that you reduce the bond to $15,000, Judge.
And the other case is definitely indicted, so he hasn't been in 500. The other case is indicted, right?
That's correct. I believe it
Okay,
is,
so
Judge.
he just was charged with this in September. I'm
Right.
still gonna email the DA's office and tell them ones that have been in over like 200 some odd days, see what they can do with them. Go ahead. What says the state? Ms. Simmons?
Yes, Your Honor. This defendant is in jail on some very serious charges, 2 counts of armed robbery and possession of a firearm. And while in custody, the allegation is an aggravated assault where another inmate was injured. And so, Judge, that alone says to us that this defendant is a risk of reoffending and does pose a danger to the community if while incarcerated under the supervision of the jailer, he is engaging in violent acts in the jail. And so, Your Honor, on that basis, the state would object to any reduction in the bond as set, because the bond is reasonable in all the circumstances, and there has been nothing brought forward which would necessitate the court going behind that initial decision of the $25,000 bond and reducing it. Nothing has changed, no material change in circumstances, and on that basis, the state would ask that the bond as set remain in place.
Judge,
Yes.
there's an $86,000 bond on that other case.
All right, thank you. No drugs unless prescribed, no alcohol, no weapons, no further contact with Marcus Freeman. No further contact with your alleged co-defendants. So you've got Chaz Banks, Jermaine Watts, Cordaz, Cordaz Harmon, Antoine Bird, Byrd, Alfred Dodd, Dodd, Octavian, Octavian Williams, Willie Stinson, Stinson, and Danovan, Danovan, last name Sorto. It's hyphenated, so it's hyphen Castellanos, Castellanos. No further contact with them. You're going to have an ankle monitor once you get out, paid for by the county with a 24-hour curfew, court, lawyer, work, and medical. You have to supply the name of your employee, place of employment, proof of employment, and make sure you supply the schedule. Give it to Mr. Tessier, who will give it to the state. And you also need to let the ankle monitoring company know. So we will reduce this to a $18,000 good bond. Best of luck to you, sir.
Judge, only a concern there is being that he does not have control over where he is placed in the jail.
Well, I'm sure Lieutenant McDaniel will do what he needs to do. I mean, obviously, if Lieutenant McDaniel, if they still have him in the same place, which I kind of doubt, I don't know. I'll leave it up to Lieutenant McDaniel's discretion.
All right, Judge.
So,
that's all
Ms. Young,
for
you
me
can put
today.
it in there that if housing is assigned and they're there, but he shouldn't have any kind. You can still be on those. Don't talk to him. I'm sure your lawyers wouldn't want you talking to each other anyway. So obviously, you can't help what LT where he gets assigned.
Thank you, Judge. That's
All
it
right.
for me. May I be excused?
Absolutely. Have a good evening.
You too. Take care, Judge.
You too. Is Patrick Thomas. All right, it's position 15, Bostic 22, CP 213156, Patrick Thomas. 107 days without indictment, and we've got a no bond as of October the 13th. Now, were any of these dismissed at a prelim?
Yes, Your Honor. I was
One
gonna
ag
bring that up.
assault and the 2 reckless conducts, right?
Yes, Your Honor.
All right, so it's just 1 aggravated assault, and it's no bond on the 1 aggravated assault as of 10/13. Patrick Thomas, raw.
Patrick Thomas, 7 prior arrests. First offender on a theft by receiving stolen property misdemeanor that was revoked. 2 other misdemeanors. Did not write down the open charge on the 22 CP 208-324 open case in Cobb County for simple battery, family violence, and a misdemeanor obstruction. Nothing further.
All right, go ahead, Mr. Gazoli.
Thank you, Your Honor. Mr. Thomas is 31 years old. He has 3 children. 2 of them live, I'm sorry, Your Honor. He has 3 children, and all 3 of them live with him, a 12-year-old, a 6-year-old, and a newborn. He is a high school graduate and attended a little bit of technical college, and he's previously employed at AAA Roadside Assistance and will be allowed to return to that job upon release. He's lived in Georgia for 17 years. He has a good address at 3435 DeVoe Court, Marietta, Georgia. Your Honor, as you mentioned, he is currently on no bond status. He is now statutorily entitled to a bond. He was originally arrested for 2 counts of aggravated assault and 2 counts of reckless conduct. Your Honor, I know you have to can't really consider the facts of the case, and there was probable cause found for one of the aggravated assaults, but Your Honor, there was in brief, it was overheard 4 shots fired. Nobody actually saw that gun fired, or who fired it, and that was the underlying facts of this case. So we are asking for a bond, Your Honor. We're asking for a bond not to exceed $8,000 good on the single aggravated assault charge.
All right, what says the state?
Dear Melissa Roth for the state judge. This individual also has another open case, which is 22 CP 208-324. In that case, that is from a April 15th, 2022 incident where the defendant pushed the same victim as that in the case ending 156 while she was pregnant. She was 4 months pregnant at that time, and the defendant was also blocking her from leaving the location. That was on April 15th of 2022. So this current incident is from September 9th of 2022. The defendant arrived to pick up the child that they share together. And the victim at that time saw the defendant with a gun and saw that he was intoxicated, and as a result did not want to do the child exchange. The defendant became very agitated. As a result, the victim's sister was also present, and my understanding is had filmed a portion of it. There were 4 shots fired. There were no casings recovered on scene, Judge, but the shots fired were immediately following the verbal dispute that the victim and defendant were in. And after the shots were fired, the defendant immediately left the area, Judge. Based on this, the state is concerned with the escalation of conduct by the defendant. He did have he has a $10,000 bond in the case ending 324. Based on the escalation of conduct, Judge, the state is asking for a $50,000 bond, no weapons or replicas of weapons, no further contact with the victim or the victim's sister, who is a witness in this case, and a stay away from the incident location, Judge.
Is the victim's sister Kedrice Green?
Yes, Judge.
Okay. No drugs unless prescribed, no alcohol, no weapons. Gonna have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical, and work. Provide proof of employment, name of your employer, schedule, and the exact location you'll be working, sir. However, you're gonna have to stay out of Fulton County. So if you go back to AAA, you can't take any calls in Fulton County. You can only come back for court and to see your lawyer, because you're gonna stay out of Fulton County except for court to see your lawyer. If anything pops up where there's a hold, you'll have 48 hours to have that ankle monitor placed on your ankle. Stay away from 2128 Jasmine Parkway in Alpharetta. Which you shouldn't have a problem because that's in Fulton County. No further contact with SHAKEEMA Perry, PERRY, and Cedrese, CEDRESE Green, common spelling. I think that was it. Sorry, trying to read my writing. Stay out of Fulton County, ankle monitor, 48 hours a case, and I'll do a $25,000 good bond. Best of luck to you, sir. You can leave the booth. Jaquez Perry. Excuse me. All right, Mr. Nobles, you on here? You got 2 cases. It's a 3 and 4 Bostic. 22 CP 208977 Jaquez Perry, 261 days without indictment. This is a $1 million good bond for 5 counts of ag assault. And that $1 million good bond is good as of August the 23rd. And position 4, 22 CP 208978 Jaquez Perry, 261 days without indictment. As of May the 12th, there is a $11,000 good bond on possession of firearm by a convicted felon and willful obstruction misdemeanor. Wow.
Judge, in regards to Jaquez Perry's violent history, 17 prior arrests, open case 22 SC 184447, battery, family violence, 2 counts, aggravated stalking, cruelty in the third, Lethbridge. On probation for 2019, firearm by a convicted felon, sentence in 2019, 6 months confinement, 2 years, 6 months probation. That's from May of 2019. Theft by receiving stolen property, conviction, terroristic threats, conviction, criminal damage to property. Also on probation for street gang activity out of Richmond, sentence in 2021 for 5 years, prior FTA in 2016. Nothing further.
All right. Go ahead, Mr. Nobles.
Yes, Judge. Mr. Perry has been in custody for 261 days on these charges. And he has not had the benefit of an indictment or a preliminary hearing to really examine the merit behind these charges. He currently, on this aggravated assault case, has a bond set at $1 million, which I will put forward as an unreasonable amount. Mr. Perry is indigent, that's why he has my services. I don't believe I have any clients who could afford to post a $1 million bond. There's probably few in the community who could. So we are asking the court to reduce that. Prior to his arrest, he was receiving benefits from the Social Security office. Those have ceased. So he now is without any source of income. That is a material change of circumstances that affects his financial ability to post a bond. I'm asking the court to also keep in mind his ability to pay when you set this bond amount. A little bit about the case at the aggravated assault. I won't go into the details, but the witnesses do say nobody saw him do this and nobody was hurt in this instance. As to the second case, the possession of a firearm case, he actually was a passenger in a vehicle, and other people in that vehicle claimed it. This is all according to the warrants, claimed ownership at the time that he was arrested. So we do believe that he will be exonerated in due time. We're asking the court to reduce his bond at this time. He is a native of Atlanta, Georgia. His mother lives here. He has 6 children who reside all in the state. So his ties to this area are extensive. When he's not at risk to flee, I put forward due to these ties. And I also do not see any history of Mr. Perry failing to appear. So I believe he would be a good risk for Your Honor to take as far as appearing in the court. He would not flee this jurisdiction. He's not opposed to any stay away order or a 24-hour house arrest if that's ordered. We're just asking the court to reduce his bond to an amount is reasonable that he may have a hope of making. As to the aggravated assault case, we're asking for it to be reduced to $4,000 on each count. That'll be a total of $20,000 bond. And for the possession of a firearm obstruction case, we're asking to cut that in half to a bond of $5,500.
All right, what says the state?
Your Honor, Mr. Perry is a violent offender who has an extensive criminal history, as was recited by pretrial. The allegations in the case involved firing into an apartment which was occupied by 4 people at the time, including minor children. State is extremely concerned about Mr. Perry being a risk to the community, as he has demonstrated over the years by his willingness to engage in violent conduct, and doesn't seem to have accepted that he needs to abide by the laws of the land. He seems to be bent on a path of being incorrigible. With every chance that he has gotten, he has found himself back in trouble with the law. With respect to the bond as set, Judge, the state would not oppose a reduction from the bond, but the state would defer to the court with respect to a reduction, because we do believe a reduction to 20,000 in light of Mr. Perry's extensive criminal history and also the seriousness of the allegations against him, we would think would be extremely inappropriate, Judge. We would ask the court to consider possibly something in the region of 150,000.
All right.
With respect to the aggravated assault. With respect to the possession of a firearm charge, Judge, the state does not object to a reduction in that bond.
All right, so I'm reading the words on the ag assault. It says, they spoke with one of the alleged victims, Ms. Warren, who stated on the night of the incident she was laying in her bed with her oxygen tank when she heard the suspect, Mr. Jocko S. Perry, outside her window. Stated that the male said, "Y'all ain't going to fuck with me. I told y'all I'd be back." Ms. Warren stated moments later that she heard shots fired at her home. Ms. Warren has known the suspect for 15 years. Her son went to school with him. She did a photo lineup and picked him out. Mr. Jaquez, as the suspect, shot up her house and pointed a gun at her daughters and her nieces. Other victims of the case were juvenile. So that's what it says. It says they found shell casings, et cetera, et cetera. So here we go. On position 3. Some judge said $1 million bond. That was a mean judge. Wasn't it, Mr. Nobles?
I have no comment, Judge.
That's why I love Mr. Nobles. He's awesome. All right. No drugs unless prescribed, no alcohol, no weapons. Where is he? Is he still going to he's going to live at that address in Fulton County?
The address I have is 314 East Ron Hill Road.
4 North, sit down.
Southeast Atlanta 30315. So yeah, that should
All
be Fulton County.
All right. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. No further contact with Corman, Carmen, Lupo, Lupoe, Heaven, Warren, common spelling, Heaven and Warren, Deborah, Thomas, Warren, Dariana, Derriana, Clemens, Clemons, Tatiana, Tytiana Green. I think that was all of them there. Make sure. Sorry, guys. You know, I have this other screen beside me I look at so I can read the stuff on the screen. No further contact. Well, before it said, I swear that no further contact with any gang members of any gang. This I don't have it open showing which gang allegedly you were affiliated with, and also no replicas of weapons. No drugs unless prescribed, no alcohol, no weapons. That ankle monitor will be paid for, like I said, by the county. So what we'll do here is $50,000 on each aggravated assault in there. So that's 50 times 5. And on position 4, no drugs unless prescribed, no alcohol, no weapon. You got an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. And I've got 5,000 and then 250. 5,000 and then 250. And by chance, if there's a hold anywhere, you'll have 48 hours to have that ankle monitor placed on your ankle. And sir, just so you know, I'm sure Mr. Nobles have told you, you can't even ride in a car with somebody. You can't be in a house with somebody that has a gun because that's a violation of, you're a convicted felon. And you're in possession of it if you're in the house with it or in a car with it. All right. Best of luck to you, sir. You can leave the booth. And is that it for you tonight, Mr. Nobles?
Yeah, that concludes my business. May I be excused, Judge?
Yes, sir. Have a good evening.
All right, you too.
All right. Mr. Sampson here got Antoine Brown. All right, we got position 18, Bostic 22, CP 212128, Antoine Brown, 141 days without indictment. As of September the 15th, there's a $15,000 good bond on robbery. Free. Rah.
Judge, in regards to Brown, 3 prior arrests, no felonies, 1 misdemeanor conviction, nothing further.
Go ahead, Ms. Sampson.
Yes, good evening, Judge. Mr. Dixon has been in the Fulton County Jail for 310 days now, and on this unindicted case, he's been there so long, Your Honor, that his charges have actually changed. His preliminary hearing that was held on September 2022, he had 3 charges, and now he has 1, and the aggravated assault he had initially has also been changed as well. Your Honor, at this time, he has a $10,000 bond that he clearly cannot afford. I'm asking that his bond be cut in half, Your Honor, at this time. He's skating towards a year, and he's also had a birthday in there. He's gone through every stage of pre-indictment that pre-indictment can afford at this time.
All right. What says the state?
Good evening again, Your Honor. ADA Jordan on behalf of the state. Your Honor, the state would be opposed to any reduction in bond. According to Mr. Brown's GCIC, I do see 9 cycles, a 2017 burglary out of the cab, a 2019 conviction for burglary out of the cab as well. I also see a 2021 pending kidnapping out of Clayton County. Your Honor, given the Mr. Brown's criminal history, the state believes that the $10K bond, I believe that it was said previously, is an appropriate bond.
So it's 15.
15, Your Honor. Well, the state would, given the amount of time that it's taken to indict this matter, would consent to a bond of $10,000, but no lower than that, Your Honor.
All right.
The bond is presently 10,000, Your Honor.
Oh, I've got 15.
Attorney Sampson, I think I'm covering for you on this one.
Mr. Dixon?
No, for Antoine Brown.
Oh, my apologies. I got this is a different person, Your Honor.
All right, yeah, this is 15. All right, so it'll be a $10,000 good bond. Ms. Young put it on there that the state agreed to that. No drugs unless prescribed, no alcohol, no weapons. Stay away from 232 Forsyth Street Northwest. Where's he going to live, Mr. Cazzoli?
I'm sorry, Your Honor, one moment here.
Or Miss Sampson, let me see. His booking sheet's pulling up.
Yes, Your Honor. So it is going to be, it's only a mailing address, and it's 1458 Van Vleck Avenue Southeast, Atlanta, Georgia.
We don't know where he's going to live.
He's currently residentially challenged, Your Honor. He wants a program. I believe that we've reached out to a social worker to get that together.
Okay. All right. You have ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, MH or addiction treatment that your lawyer gets you into. You can work as long as you supply the name of your employer, proof of employment, location, and schedule. You have to supply that to the ankle monitoring company and to your lawyer so that she or he can supply it to the state. No further contact with your co-defendant, Curtis Clayton. $10,000 good bond. That ankle monitor will be paid for by the county. Best of luck to you, sir. You can leave the booth. All right, I got Brian Wilson. Miss Collins. Do I see Miss Collins? There she is. All right. That's position 11, Bostic 22 CP.
Actually, Your Honor, I would waive sounding on the pretrial reading and just in general for this entire hearing, I would waive sounding.
Okay, well, yeah, Bostic good at that. But 22 CP 213124, Brian Jamal Wilson, 107 days without indictment, no bond as of October the 12th. On 107 days on aggravated assault. Trial. Boston. You're on mute, Boston.
Sorry, I was just reading.
Okay.
26 prior arrests, 2 FTAs, couple of arrests for battery, for probation violation, cruelty in first, battery in the third, 2 counts, false imprisonment, 4 years, confinement, 6 years probation, 18 SC 158410, sentence in 2020, first offender on a CWAC convictions, at least 2 burglaries, 5 arrests for misdemeanor, nothing further.
All right, go ahead, Ms. Collins.
Your Honor, Mr. Wilson, he has been incarcerated for 107 days approximately. He is in a no bond status. His case is unindicted still. He has not had a preliminary hearing on this case. He is entitled to a bond statutorily given the amount of time he's remained in custody without indictment. And Your Honor, we would request a reasonable bond given the amount of time that he has been in custody without any hearing prior to this one. Just some background information on Mr. Bryan. He's 33 years old. He turned 33 while incarcerated. He has lived in Georgia now for 31 and a half years. So he moved here when he was just an infant. He has his family here. He does have a good address, which should be on file. I just updated his address about 10 minutes ago. So the address on file most recently is his address. I've contacted the owner of the home and confirmed that he will be allowed to reside there. He does have his GED. He does have a child. He has a 9-year-old daughter. Prior to getting arrested, he was working at a thrift store and also working at Holiday Express. He has been incarcerated for almost 3 months now, so he does not have any income to put towards a high bond. He has been accepted into and is receiving services through PAD. His care navigator, Miss Eris Montanero, she is on the line right now observing the hearing. And if you have any questions, she is there to answer them. I also have an acceptance letter if Your Honor would like to see it, and I could also send it to the ADA handling this case, which I believe is Miss Simmons. Your Honor, we are asking if you would consider a $5,000 bond. The reason I asked for the low bond, and I understand that this is just a bond hearing, we haven't had the opportunity to have the prelim yet. It was previously reset, but we do have a date on it. But the allegations in the warrant are quite alarming. First and foremost, it states that Mr. Wilson was stabbed in the back by the alleged victim. It does not state that the victim was harmed in any way, shape, or form during this alleged incident. The victim alleges that Mr. Wilson entered her residence. However, the warrant states that the officers were not able to locate a crime scene. The incident location on the warrant appears to be a convenience store. And so I'm just a little bit confused about how this could happen in a residence and the residence be unknown, even though they spoke with the alleged victim. Again, the allegation is that he was stabbed in the back while reaching for a cigarette. It does not sound like that anyone was in danger. I'm not understanding why Mr. Wilson was the only one charged. It seems like he was attacked in a position where most would consider him to be defenseless, being that his back is turned and he's reaching for another object. The victim does admit to the stabbing. The knife that she used was recovered. There was no knife recovered from Mr. Wilson. There are no witnesses that say they ever saw Mr. Wilson have a knife or attack this individual. It sounds to me like someone stabbed a defenseless individual and they're just trying to make their way to the police first and create a story. But we understand that's something that we will investigate further during a preliminary hearing if we have the opportunity. But Your Honor, we would ask for a $5,000 bond so that Mr. Wilson has a bond that is obtainable or doable for the Bell Project to do so that he can be released and continue to receive treatment through PAD.
On the other, has he got a bond on the CWAC charge? Because in the warrant it says that.
Your Honor, he has not been charged with that. There is no charge.
I say it says that there was a warrant out for his arrest.
I understand, but at the time he was picked up at this offense, he was never charged for that. I have not been able to locate a warrant. I am not sure if it's just the statement of the complaining witness, but he has never been arrested and presented with a warrant for that charge, and I have not been able to locate a warrant for that alleged charge. So I'm not sure.
It just says upon my investigation there was a warrant out, so I didn't know where it was or
what the case number appears to be an APD case number, so I'm unsure of if it is. He has not been. It has not been presented.
Okay, what says the state?
Your Honor, I can cover for the state on this position. The state would oppose any bond that would be lower than $15,000. Your Honor, as Attorney Collins was stating, this is an allegation where both parties were supposed to have knives, and that we do understand that Mr. Wilson was stabbed as a result of this, but it sounds like as part of the investigation, they did believe that the victim was threatened with a knife first. Mr. Wilson has a GCIC that's 42 pages. Your Honor, given the violent nature of this particular offense, the state would suggest a bond in the amount of $15,000.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Ashley Todd, TODD. Have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, work as long as you supply the name of your employer, the location, proof of employment, and your schedule. You have to supply that to your lawyer, sir, and to the ankle monitoring company. It looks like there's a couple other things that are out there pending. So you'll have 48 hours to have that placed on your ankle once you're released from any possible holds. Stay away from 729 Cascade Avenue Southwest. $15,000 good bond. Best of luck to you, sir. And then, Ms. Collins, as long as you got a bond motion, if that's on my calendar, I'll hear argument then too on bond. You know, I do that at prelims anyway.
Oh, okay. I guess, well, I mean, he has a prelim, but I doubt that the bond is gonna be reconsidered. I
It's
just
in
would
front of me.
state,
I reconsider bond at every prelim.
I would just state that for the record, he is not going to be able to afford that bond. And I know he does have some cycles there, but most of those are pretty, well, most of the felonies are pretty old. And I do see from my notes in pretrial and from my copy of the GCIC that his last arrest was 5 years ago in 2017.
Well, I'm going to be interested on the second to hear from the arresting officer. But you know me, Ms. Collins, I always consider bond. If you're in front of me, let's do it.
All righty.
All right. All right. Best of luck to you, sir. Next, we've got Jarvis Brown. Mr. Brown. Jarvis Brown. No Jarvis Brown?
I'll check on him with Lieutenant.
Okay, what about Nasir Mead? Kevin Varner. Kevin Varner. All right. Kawan White. All right, now we're cooking with gas. Ms. Bassett. Is position 4, Bostic. 22 CP 207603. Kawan Dimitri White. 314 days without indictment. There is a $357,000 good bond September the 6th. Aggravated assault, robbery, possession of a knife or a firearm during the commission of a felony, discharge of a firearm near a public highway or street, simple battery, and terroristic threats and acts. Rob.
Only prior arrest, Judge.
All right, go ahead, Ms. Bassett.
Thank you, Your Honor. Mr. White is 19 years old. He is from the Atlanta area. His entire family is here. I have spoken with his parents numerous times, and they are loving and supportive of Kiwan. He was a senior at Langston Hughes High School. He was on track to graduate in May of 2022. That has obviously been derailed. He was working as an assistant manager at a McDonald's in Union City. As you heard, no prior arrests. I don't believe that he has any juvenile history either. The state's allegations in this case are that Kiwan, who was a passenger in a car that had just been involved in a fairly serious collision, Kiwan's mother suffered from several broken bones and had to be hospitalized. And Kiwan was a passenger in this car. The allegation is that he jumped out of that car, fired a gun several times, shot the man who was driving the car that Kiwan and his mother are in, then runs up to the driver of the other car, robs him at gunpoint, and then runs back over to the driver of the car he has been in and starts punching him in the face. This is bizarre to me. I did handle the preliminary hearing in this case, and I found the testimony to be fairly inconsistent. There is a video and a third-party witness that are mentioned in the report. What is not mentioned in the report is that the officer testified at the preliminary hearing that this person was over 150 feet away. So there's some distance there. Kiwan is, by any other account, a nice, polite young man who stays out of trouble. And he doesn't have any mental health conditions. He also has not had any jail incidents in the 314 days he's been in custody. Although he did have to be relocated to a different area of the jail because other inmates were threatening him and were being violent towards him. I am hesitant to get too deep into, I guess, my take on the facts or my theory of the case at such an early stage, particularly because the state has not turned over any discovery.
Defense counsel has not been afforded the opportunity to view any purported evidence that may or may not exist in this case. That being said, I do have a difficult time believing the state's version of events. I just have to think that there would be more to this story, because otherwise I would think that the state would have gotten around to bringing an indictment by now, particularly since we had the preliminary hearing on this case back in September. As far as the bond goes, Kiwan is young. He does not have the financial resources to make a bond. His family might be able to post a reasonable bond for him, but $357,000 is not even remotely reasonable. I would ask the court to consider reducing the bond to $100,000, and I would ask the state to put on record when they expect to decide whether or not to formally charge this case.
All right, what says the state?
Yes, Your Honor. With respect to the reduction in the bond from the $357,000 that is currently set at, the state would not oppose a reduction in the bond, but not to the $100,000 as put forward by the defense. The allegations in the case are very serious. Whether or not counsel agrees with the state's version of events is for another forum that can be where the facts of the case can be gone into in much greater detail. At this point in the proceedings, no discovery has been provided because the case has not yet been indicted, and we're not at that position yet. But the allegations by themselves, Judge, are extremely serious with regard to the defendant firing a weapon on a public highway, shooting at the victims, and showing a complete disregard in his actions for the consequences of discharging a weapon in the way that he did. And so, Judge, while we would agree to a reduction in the bond, we would certainly ask the court to consider a bond of $150,000 rather than the $100,000 that defense is asking for, in light of the seriousness of the allegations, but also balancing that, Judge, with the fact that the defendant has no criminal history.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Travis Davis, Coley, Coley Carter. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical appointments, and I guess if he's going to finish school, as long as he provides proof of enrollment and his class schedule, and also work. If he wants to get a job, work, as long as he supplies proof of employment, name of employer, schedule, location, he'll be working. And he's still going to live in Fulton County, right?
I believe so, Your Honor.
Okay. All right. So I'll do 25, 25, 20. Wait a minute. 25, 25, 10, 10, 10, 5, and 5. 25, 25, 10, 10, 10, 5, and 5. You got that, Michonne?
I couldn't come off mute. Yes, ma'am. 25, 25, 10, 10, 10, 5, 5.
Yes, ma'am. Best of luck to you, sir. Was that it for you? No, you got another one, Miss Bassett. Sorry. All right. Jarvis Brown. Did you ever come in? No, Jarvis Brown. Kevin Varner.
Judge, they're going to rotate in and out of 5 South once the gentleman in booth 2 comes out.
All right. Michael Hall.
That's my case as well, Your Honor.
Ahmed Dixon. All right, there we go. Sir, you have a nosebleed or something? You keep holding that to you, or does it just smell bad? Something pointed out about his head. I don't know.
Yeah,
Okay.
it's the product on his hair, Your Honor, that he's.
Oh, he's like
covering- the
bleaching
reason why
his
he's covering
hair or
his-
something.
It's not bleach. It's just product. It's
Oh.
something for his skin.
Oh, okay, like eczema stuff. Okay, I got you. All right, I couldn't tell what it was. All right, Ahmed Dixon. It's position 1. It was on that other counter where it's reset from the 12th because of the issues, the weather issues. 22 CP 207707, 310 days without indictment. As of September the 2nd, there is a $10,000 bond on aggravated assault. The other 2 charges were dismissed. Pre-trial.
15 prior arrests, prior FTA, three prior misdemeanor convictions, 1 being a battery, 4 arrests for probation violation, prior forgery, FTA in 2022. Nothing further.
All right, go ahead, Ms. Sampson.
Yes, Your Honor. Mr. Dixon is 36 years old. I did not hear an extensive felony criminal history, Your Honor. As you mentioned, he has been in the Fulton County Jail for 310 days on this $10,000 bond that he cannot afford. Your Honor, he is residentially challenged at this time, so we'd have to wait until his bond is around $5,000 to be able to get him assistance from the Bail Project as well as assist him with housing at this time. As mentioned, he has had every stage of the pre-indictment division at this time, Your Honor. I'm asking for a bond not to exceed $5,000. He's already had his preliminary hearing, and that was September 2022.
All right. What says the state?
ADA Jordan on behalf of the state, Your Honor. The state, given the allegations in this particular case, while the state is completely understanding of the amount of time is concerning for this case to have been indicted, which we are nearing almost the 1-year mark, that the allegations are serious enough here where that Mr. Dixon did pull a knife on an officer, that we would request that the bond be left at $10,000 with the same conditions, Your Honor.
All right. Well, since it has been 310 days, see, no drugs unless prescribed, no alcohol, no weapons, no further contact with Kevin Knapp, KNAPP, unless it's his official duties. Stay away from 209 Peachtree Street. Get an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment, as long as you supply proof of employment, name of your employer, schedule, and the exact location you'll be working. Sir, you'll have to supply that to the state, to your attorney, and also to the ankle monitoring company. And you just say he's going to still live in Fulton County, right?
Yes, Your Honor.
Okay. $7,000 good bond. Best of luck to you, sir. Because before you asked for $7,500, $7,000. Best of luck to you, sir. You can leave the booth.
That concludes my business. May I be excused?
Yes, ma'am. Hope your head gets better, sir. All right. Let's see. You can go ahead and leave, sir. Thank you. All right. Nasir Mead. Oh, all right. Hold on. Michael Hall. All right. There's Mr. Hall. Position 5, Bostic. 22 CP 206233. Michael Hall, 360 days without indictment, aggravated battery, aggravated assault with intent to murder. There is a $70,000 good bond as of April the 20th, 2022. Pre-trial.
Okay, now I'm lost. This is who?
Michael Hall. It's on the 24 of 25 calendar.
Can you see? Michael Hall?
No, maybe it's on the other one. Hold on. Yeah. No, I'm
I
sorry.
have
Maybe it's
him
on-
as position 5 on the add-on calendar.
Yeah, it's on the add-on calendar.
And then I am the daughter of the
Okay,
victim.
stand by,
in this
ma'am.
case.
Ma'am, nope, can't talk yet. The one that says there's 6 positions. Bostic. Same one with Kawan White was on. And Miss Walker. I apologize for interrupting you, but I can't hear from you right yet, ma'am, okay?
Kawan White?
No. It's on that same calendar with Kawan White and had Miss Walker. That same calendar. It's got 6 on there. You got Odyssey open. The one that says 6.
Nope, don't have that one. I thought I had.
All right. Jimmy here for them. Can you run it?
I can pull it up right quick. What's his name?
Michael Hall. You know his booking number?
Oh, Michael.
Yep, it's still Michael Hall, isn't it, Miss Bassett? He hadn't changed in the last 2 minutes what his name is.
As far as I know, Your Honor, he has not.
You sure it's not Michael?
It's Michael Hall.
All right, thank you, Bostic.
Just a second. Michael Hall. FTA in 2015, he has 4 cycles. Open case in Georgia, 21 CR 008027Y for driving with a suspended license. That's it.
All right, go ahead, Miss Bassett.
Thank you, Your Honor. Mr. Hall is 50 years old. He has been in custody for 361 days. His bond is currently set at $70,000. He has no means of making that bond. He is from Georgia. He does experience MH issues. I do have an open social work request for him. We're trying to get him some healthcare assistance and some housing assistance. We did have a preliminary hearing for Mr. Hall back in July. At the time, the state was having issues locating the complaining witness. I do see that Miss Lee, I guess she had identified herself as the complaining witness's daughter, so she might be able to assist. Because really what I would like is for this case to move forward. Mr. Hall has no hope of making any bond. I'm going to ask for a reduction today, but he's not going to make any bond. My understanding is that this is an alleged incident that occurred at a homeless encampment. It is unclear exactly how a nexus was formed or how the officers formed a nexus between Mr. Hall and the person who was injured, or how did they ID Mr. Hall as the person who did this. I do know that the officers liked Mr. Hall for another unrelated case, but we've now reached the 1 year mark, and in addition to the state opting to do nothing with this case, they have not done anything as far as any other case either. So I think it's safe to say that the officers no longer like Mr. Hall for that other case, and I'm not entirely sure why we're here if the state doesn't intend to move forward. As I said, Your Honor, I'm asking for a reduction, any reduction, and I'm also asking for the state to indict or dismiss this case.
Okay. What says the state?
Your Honor, at this time, the state would oppose any reduction in the bond, not just because of the seriousness of the allegations, but because of Mr. Hall's extensive criminal history. Mr. Hall has 34 cycles, Your Honor, and in and amongst his convictions are convictions for aggravated assault, terroristic threats, criminal damage to property in the 2nd degree, a number of misdemeanor battery charges, Judge. So his criminal history does include some violent criminal history plus probation violations. And on the face of the warrant, Judge, this is an extremely violent attack that was perpetrated on the victim, Miss Lee, where the allegation is that Mr. Hall took a rock and struck her in the head and then pounded her head and her hands into a rocky outcrop. Miss Lee suffered extensive damage to her head and to her hand, which she had put up in a defensive motion to ward off the strikes with the rock. And the extent of the damage was such that Miss Lee eventually had to have her finger amputated. And so, Judge, in light of the extensive violent criminal history of this defendant and the violence of the attack on the victim, as alleged by the state, we would oppose any reduction in bond, because I think the $70,000 bond is a good bond and a reasonable bond in all of the circumstances.
Your Honor, if I could just very, very briefly, the information that I have has Mr. Hall's, the most recent aggravated assault conviction is 2006. I was still at high school in 2006. So
are you rubbing that in, Miss Bassett?
It was quite some time ago. So And I also have a copy of the police report, and I can say that a lot of this is the officers explaining how they did not believe Miss Lee, how they did not take her seriously. And honestly, I find that tragic that somebody who's asking for medical assistance can't get it. But I do think that there were some days that passed between the officers actually taking her seriously and their decision to arrest Mr. Hall. I'm just not convinced that they have the right person. I'm not saying that this didn't happen to Miss Lee or that her circumstances aren't tragic. I don't know that she actually did have to have her finger amputated. When I last got an update on that, nobody had taken any steps to even locate her, let alone confirm whether or not that was the result. But again, I'm just not convinced that it was Mr. Hall.
All right. All right, Miss Lee, if you want to take yourself off mute and raise your right hand for me. You swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right, so is your mom there? Is she asleep? You're here for her? What?
I reside in Texas.
I can tell. I hear that Texas accent.
So my mom is homeless in Georgia. I have been down there to try to get her to come home multiple times, but that's a different story, or come to Texas multiple times, different story. I did go to the hospital whenever this event happened. My mom called me very frantic. She did have a severe concussion. She had some issues going on with her shoulder. She had a broken hand. I would have to look back at the pictures, but I can't recall off the top of my head. And she did have to stay in the hospital to have her finger amputated. That was whenever I was in constant communication with my mother. Now she calls sporadically. Usually it's, week to week basis whenever she has a phone. I do not know where my mother is. But the last I talked to her, it was, may I pull up my contact log?
Yes, ma'am.
The last I spoke with her was on the 11th of January. And she asked me if I had heard from the attorney's office, and, she's trying to get in contact. She doesn't have the means as far as a phone. I don't know the area, so I don't know if she could walk there. I have no idea. But she did say that she was terrified of this man getting out, whoever he is.
Miss Lee, maybe next time you talk to her, if she goes by, she knows where the courthouse is. Where this allegedly happens, not far. It's like a few block, block maybe down from the courthouse. There's a Catholic church on Central, right across the street from the newer courthouse building, is called Our Lady of Immaculate Conception. And I think it's once a month where they have free phones that they give away. Isn't that right, Miss Bassett?
I would have to ask one of my social workers here.
Yeah, I know there was a social worker on here before, but I think it's once a month. Our Lady of Immaculate Conception. I think it's once a month they give away free phones if she needs that.
Well, I sent her a watch in her care package. So I'm like, you know what time it is? Like, you got to do something.
All right. Anybody got any questions for Miss Lee?
No, Judge.
No, Your Honor, just whatever Miss Lee can do to help get her
Absolutely.
mom. Yeah, I appreciate you being here.
Yeah. Miss Bassett, do you want her to put her contact info in the chat or put your contact info in the chat to Miss Lee or Miss Simmons so that she can give that information to her mom?
Judge, I had actually asked Miss Lee to either send me her contact info in the chat or email it to me. I provided her with my email address. So
okay.
I'll get
Miss Bassett, I guess if you want to put yours in there to Miss Lee, if she wants to reach out.
I have no idea how to work this, so I don't know if anyone's chatting to me or not.
There's probably three dots. I don't know if you're on an iPhone. If you hit those three dots, or once she sends a chat, if she sends it directly to you, it'll probably pop up on your screen.
Oh, got it.
And Miss Lee, I am going to provide you with my office phone number and my email address. I'm going to send you a private message in the chat. Just so we're clear, I am the defense attorney. So if you choose to communicate with me, I'm just doing my job. I'm not like the enemy or anything, but
you're fine.
Okay.
All right, while we're doing this, it's like, no drugs unless prescribed, no alcohol, no weapons. He's gonna have an ankle monitor with a 24-hour curfew except for court, lawyer, medical. No further contact with Sonya, Sony. Lee must enroll, and this was on here before, he must enroll in some sort of mental health treatment program and attend and take all medications as prescribed. So, Mr. Hall, make sure you listen to Miss Bassett, okay, and do what she says, and their social worker will probably find you housing. So you'll have to provide an address upon bonding out. So I'm sure the social worker will be in touch with you. They'll get you some housing and they give you an address where you'll be staying. All right. 25,000. And Miss Bassett, last time I sent a list to the DA's office, I'm gonna send another list after at the end of the evening on cases that are really old that need to be indicted. So I'll be glad to put that one on there so we can't make it moving.
Thank you, Your Honor.
All right. Thank you, Miss Lee. Have a good evening.
You as well.
All right. Jarvis Brown, are you in here yet? Now let me go back down here to Kwan Johnson. Kwan Johnson. Nope. Quinson Beavers. Thank you, sir. His position 4 was on the reset from the January the 12th calendar. Bostic. Quinson Beavers, 22 CP 212168. 140 days with no indictment. We got trafficking in illegal drugs ×4. BGCSA schedule 345 controlled substance with intent to distribute, and that is ×2, 2 of those. And possession of a knife or a firearm during the commission of or attempt to commit certain felonies, possession of firearm by a convicted felon, possession and use of drug-related objects. There is no bond as of September the 9th. Pre-trial.
Quentin, who? Sorry, Judge.
Quinson Beavers. It would be number 4 on that one that has 9 of 10. And where she goes, it's 13.88 pounds.
Got it.
What's that?
Quinton Beavers, he has 13 prior arrests, took a first offender on the cocaine, open case for firearm during firearm by Schedule 2 with the intent to distribute in Cobb, prior controlled substance convictions. Thank you.
Right,
No further.
Thank you. I got 13.88 pounds of weed, 32.8 grams of MDMA, 24.4 grams of heroin, 156.6 grams of crack, 64.3 grams of Xanax, and 12.3 grams of Oxy. All right, go ahead, Ms. Gowdy. Where's Ms. Gowdy? She was on here earlier. Where's Ms. Gowdy? There you are, Ms. Gowdy.
I was having problems.
Oh, okay. That's all right. Go ahead, Ms. Gowdy, for Mr. Beavers.
And yes, Your Honor, before the court is Mr. Beavers. He is 38 years old, Your Honor, a lifelong resident of the state of Georgia. He's been in custody now for 140 days, Your Honor, without indictment, without a preliminary hearing on this case, Your Honor. So as a matter of law, he is entitled to a bond today, Your Honor. And I will note that the bond recommendations I make to the court, Your Honor, are solely based upon Chief Brasher's standing order as it pertains to bond for drug offenses, Your Honor. But a release on bond, Your Honor, he does have an address within Fulton County. The address particular is 130 Lachey Street. That's LAWSHE, Lachey Street, Unit 304, Atlanta, Georgia, zip code 30314. He is the father of 3 children, was employed as a general contractor of sorts, Your Honor. I think that's the best way I can explain it, prior to being incarcerated in this case, Your Honor. And he was living at that address with his girlfriend, Judge. I will note per my review of the GCIC, it mostly reflects what Ms. Bostic said to the court, Your Honor. He had a 2011 case for cocaine that was dismissed. There was a 2016 first offender that was ran concurrent with another case. The cases are 15 SC 135 222, as well as 16 SC 145 328. Those are both under first offender, Your Honor, theft by taking and a drug offense, Your Honor. I haven't seen anything reflecting those first offenders being revoked, Your Honor. So I believe he's still not a convicted felon at this time, Your Honor. No FTAs per my review of the GCIC, no violations of probation, Your Honor, to my understanding. As it pertains to this particular case, Your Honor, this was as a result of a search warrant, Your Honor, and to my understanding, Upwards of 5 to 6 people were ultimately arrested in association with this offense, Your Honor. Mr. Beavers does not live at that address. None of his remnants were found at the address, meaning none of his personal documents, none of his clothing, any of those things were found at the address, Your Honor. He simply asserts, Your Honor, that he was at the wrong place at the wrong time, unfortunately. He does maintain his innocence as it relates to any drug remnants or drug objects that were found inside the home. I will also note that none of the guns or drugs were found on this person, Your Honor. As it pertains to bond, I'll just go straight down the offense sheet per how I have it on my calendar, Your Honor. The first is the Schedule 3, 4, 5. That was allegedly 12 grams of oxy. Per Judge Brasher's scheduling order, I'm asking for a $12,000 good bond. For the second Schedule 3, 4, 5, that was the 64 grams of Xanax. I'm asking for a good bond not to exceed $25,000. For both of the firearm offenses, again, we take some concern with the firearm by convicted felon, simply because by my notes, Your Honor, I don't believe he is a convicted felon, but in any event, that's something we can parse out the prelim. But for both of those, we're asking for a $5,000 good bond. Again, none of the guns were found on his person. For the drug-related objects, it's a scale. We're asking for UJR through the jail. For the trafficking, the first was 150 grams of cocaine. Per the scheduling order, that's $25,000. For the next trafficking, it was heroin. We're asking for $25,000. The next trafficking, it was MDMA. That was 32 grams. We're asking for $25,000. And the last trafficking was approximately 13 pounds of marijuana. Again, per the scheduling order, we're asking for a $25,000 good bond. So in total, that would be 125, 135, approximately 147. But again, for the Xanax, the scheduling order does not state that this has to be 25,000 because it's not trafficking. And so if Your Honor would oblige, we'd ask for 10,000 on that offense, but nothing else at this time, Your Honor.
All right. What says the state?
Your Honor, following what Ms. Gowdy did say, the state would like to note that bond was previously denied due to a likelihood to reoffend. I would like to assert that Mr. Beavers does have a charge out of Cobb County, which has very similar offenses for July 26th of 2022. So it seems like he may have made bond on those particular charges and then got these charges probably about in the neighborhood of somewhere between 40 and 45 days later. Your Honor, there was a large amount of drugs that were found here. Your Honor, the state would request a bond in the amount or a total bond of $175,000. I'm not going to embarrass myself and try to do the particular math on these offenses. I did just add up the particular figure that I did have, and the math didn't work. So I will definitely defer to the court on how, on Your Honor, and how you would like to distribute that particular number.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1295 Donnelly Avenue Southwest. I just have the name of one co-defendant, Mr. Jordan. I don't know if you have the name of another one. I have no further contact with the co-defendant, Chad Dabney, Dabney. That's the only name I have. Do you have another one, Mr. Jordan?
That's the only one I had as well, Your Honor. Ms. Gowdy may be able to
Your Honor,
help.
I'm referring to the police report in this case, and that police report cites several other individuals. I'm not sure if those individuals were arrested for this offense, Your Honor, but Mr. Dabney has been arrested thus far.
All right, let me see. Okay, so this. I don't think the police report scanned in. Okay, so you have an income order paid for by the county, the Orca project. You could leave for court, lawyer, medical, and work as long as you supply legal work, the name of your employer, the place you're working, proof of employment, and a schedule. You have to supply that to the ankle monitoring company and to Ms. Gowdy so that she can supply that to the state. Count 1, 25,000, count 2, 25,000, count 3, 25,000, count 4, 25,000. All those are per the standing order. Let's see. Count 4, 15,000, count 5, 20,000, 10,000 on the possession of a firearm, 10 on the possession of a firearm by a convicted felon, and UJR to the jail of drug-related objects. 25, 25, 25, 25, 15, 20, 10, 10, and UJR jail. You got that, Ms. Young?
Yes, ma'am. You want me to call him back out?
All right. No, I trust you, Ms. Young. You're fantastic. Best of luck to you, sir. You can leave the booth. Yes, sir. All right. And Quavius Allen. Quavius Allen. Nope. What about Kawan Johnson? Somebody wave your hand. Everybody's muted. All right, there you are. All right. This position 3 on that same January the 12th calendar pretrial. 22 CP 208487, Kawan Johnson, 280 days without indictment. There's a $10,000 good bond as of September the 14th for aggravated assault with an object. Pre-trial.
Juan Johnson. This is his only prior arrest here. Thinking is criminal trespass in Missouri. 3 and assault 2015. Nothing further.
Fair, Ms. Collins.
Yes, Your Honor. Mr. Johnson, he is 25 years old, soon to be 26. He's a high school graduate. He graduated from Forest Park High School. And he did 1 year at Missouri, but he is a Georgia resident. He just went to college in Missouri. He has been in Georgia now since 1999, since the age of 2. He grew up in Clayton County. His family still lives here. He lives at the address on file, which is his family home. I don't know why it's so dark. Can y'all see me?
No, but that's that motion sensing lightning in there.
Okay. Yeah, he still resides at his family's home, Your Honor. Right now, he has a $10,000 bond. He and his family is not able to make that bond. He has been incarcerated now for 280 days. He has not been able to work in that time. And so he does not have any money to put towards this bond. And so, Your Honor, our change in circumstances would be the lack of financial resources that he has to support the current bond that he has. As I stated earlier, it has been 280 days. We had a prelim on this case back in September. The case remains unindicted. We have pretty much gone through all of the pre-indictment phases. We've had multiple bond hearings trying to chip this bond down to something that the Bail Project can do. And here we are now asking, Your Honor, if you would consider a $5,000 bond. He does not have any felony convictions. He only has those 3 cycles I see of his entire history, Your Honor, but no felony convictions, no history of FTAs or anything to show that he cannot show up for future court dates. He also has major health concerns. He has been attacked while in custody. He still has lingering physical injuries, as you can see on him from the attacks. Prior to getting arrested, he did suffer a gunshot wound, which has left him with having a colostomy bag. And so it is a major health concern of him in being able to receive proper care and to be able to properly change out that bag, Your Honor. He also has surgeries that he needs to do regarding his gunshot injury that he's not able to do while incarcerated. So he has a numerous amount of health concerns, Your Honor, and we state that all for the reasoning of asking you to consider reducing this bond to $5,000.
And he's going to live at the Morrow address, correct?
That's his mom's home, Your Honor, yes.
Okay. What says the state?
And Your Honor, on this particular matter, the state understands that 271 days is over 271 days at this point is a long amount of time to not have the case indicted. We would assert that the dangerous nature of the charges here, and it's alleged that Mr. Johnson did return to his place of work or where he used to work and did throw a security guard and pummeled him in the face with brass knuckles. Your Honor, we would just ask that you, if you are inclined to lower the bond, that you lower it to $7,000.
All right.
Your Honor, just since we're going into the facts, we did have a prelim on this case. The investigator for the case came to testify. I believe the officer testified that there was no brass knuckles ever found on Mr. Johnson. And it was the officer's testimony that there was video footage of this, and he viewed that video footage and he was not able to make a determination whether the attacker had brass knuckles. If there's some video footage and if this officer is able to get out for prelims, I don't understand why the case has not been indicted at this point in time.
All right. No drugs unless prescribed, no alcohol, no weapons. And Drake put no brass knuckles. So no brass knuckles. But sir, that includes anything, everybody, nunchucks, throwing stars, anything like that, anything that could be used as a weapon. Butter knife. Stay away from 2353 Metropolitan Parkway and stay away from 881 Cruz Street. You must reside at 2265 Mount Zion Parkway, Unit 314 in Morrow, Georgia, 30260. And
Oh,
with
I'm
that,
sorry, Your Honor. That is, let me make sure that is his. Is that the correct address, Mr. Johnson? Thumbs up
thumbs
if
up
you.
or thumbs down, you're muted.
Okay, is it the 695 Georgetown Court address? Okay, I just want to make, because if we're going to put it on the bond order, I just want to make sure that it's
Sir,
absolutely correct.
yeah, is it in Fulton County? Thumbs up or thumbs down? Okay, because on this other bond order, you were supposed to stay at Morrow. So provide that address to Miss Collins, okay? When she sees you next, so she can put it on there. All right, well, it's not going to be in Fulton County, so you're going to stay out of Fulton County. The only reason you come back to Fulton County's court or to see your lawyer. Fill up with gas from wherever you're driving from, DeKalb County, Clayton County, anywhere. Don't run out of gas. Don't get a flat tire. Don't stop for lunch. Don't do anything like that in Fulton County. Nada. Just go into court and seeing your lawyer. Provide your address at bonding. So if you don't give them an address when you bond out or give it to Miss Collins before you bond out, they're not going to let you leave until they know an address. Okay. But you seem to think you know where it is. $7,000 good bond. Best of luck to you, sir. If you can't make it, I'm sure Miss Collins will put this right back on the calendar.
Your Honor, I mean, if the address is the concern, he's only going to be able to make bail through the bail project, and they will verify the address before they attempt to pay the bond. We've already had 2 bond hearings on this case and a prelim.
Yeah. Well, I mean, he can give it to you as long as you file an address, and then if it's in there, he'll be fine. Thank you, sir.
I was speaking on the 7,000. Could we do 5,000, Your Honor?
Mr. Jordan.
Yes, Your Honor.
He wants to know if you could do 5,000.
Your Honor, given the information that I have been given about the prelim hearing and the lack of criminal history, the state doesn't oppose the $5,000 bond.
All right, state agreed to it, Ms. Young. Boom, 5,000. Best of luck to you, sir. Still got all that stuff, ankle monitor, everything. If you get a job, you have to supply the name of your employer, proof of it, place, schedule. All right. Best of luck to you, sir. You can leave the booth.
Thank you. That concludes my business.
Ms. Collins, before you leave, 1 second.
Yes, I'm here.
Judge Manning, am I removing the must reside address that's in my?
Yeah, I guess so, since he said he wasn't going to live there. So he'll provide an address where he's going to be living. That's why when she said that, I looked at the address on the screen and it had that address. So.
Okay, I'm gonna take it off.
Okay.
That's out of Fulton County, and he does not need an address to get out of jail, right?
Well, he'll need to provide it, yeah. But if she goes through the bonding bail project, they'll like it. But if she needs to file an address, so he'll have to provide one upon getting.
Yeah, I'll file that, and I will file that.
All right, thank you.
All right, Jalen McKnight. Oh, is that it for you, Miss Collins?
Yes, may I be excused?
Yes, ma'am. Have a good evening.
All right, everyone have a great evening.
Jalen McKnight. Jalen McKnight. Derek Harden. All right, there we go. Ms. Bray, this is on the January the 12th calendar, Bostic. 21CP 201271. 568 days with a, let's see, $21,000 good bond. Aggravated assault with intent to rob, armed robbery, possession of a knife or a firearm during the possession of firearm during the commission of a felony, criminal damage to property, first degree, discharge firearm near a street or public highway, and criminal trespass.
Your Honor.
Wait a minute.
Two of the charges were dismissed at prelim back in March.
Criminal damage to property was dismissed and discharge of a firearm. So we got ag assault, armed robbery, possession of a firearm by during the commission of a felony, and just a simple criminal trespass.
Jalen McKnight, 14 prior arrests.
No,
We're open.
Derek Harden. Oh goodness, I'm making it hard for you. It's Miss Bray's fault, Boston.
It's number 9
on that calendar from the 12th.
That's all I can tell you.
Derek Harden, extensive arrest history, 26 prior arrests, 2012 possession tool theft by receiving stolen property, prior firearm doing prior battery and robbery, 4 misdemeanors, 2 arrests for probation violations, theft by taking reckless conduct, 1 FTA, nothing further.
Go ahead, Ms. Bray.
Yes, Your Honor, you have before you Mr. Derek Harton, who's 44 years old. I believe pretrial has his correct address, 2891 Springdale Road, apartment 107, Atlanta, Georgia, 30315. He is the father of 8 children, Your Honor. His children live here, his mother lives here, girlfriend, everyone lives here, Your Honor. Prior to his arrest, he was a carpentry assistant with Baker Construction. We did do this prelim back in March. So I'm not quite sure why nothing has happened on this case. I am asking the court to reduce his bond. And I know I'm going to ask for something crazy. I always do. But Mr. Harden has been accepted into the Better Way Ministries program. I do have his acceptance letter, which I can forward to the court. It is an 18-month long program, Your Honor, where he would live there. They help them work, get their life back in order. The program requires that if they're coming to pick them up, which they do, that the bond or the sentence says that the defendant must complete the program. So that would need to be in there. I can give Your Honor the address where he would be living if he is able to get to the program, and that's 800 Stallings Road, Sonoya, Georgia, 30276. And they will come and pick him up, and they'll take him right there, Your Honor, and they will notify the court of any infractions, violations, or anything of that nature. So I'm asking Your Honor so that he can go through the bail bond project. They could post his bond, and then the program could come and pick him up. So I'm basically asking for $1,000 each on the charges that he has.
All right. What says the state?
Your Honor, the state would be opposed to any reduction in bond, and I say with all sincerity, knowing about the particular time for this indictment and the knowledge from Attorney Bray that a preliminary hearing was had as far back as March, that the state would be remiss to agree to any lower bond here, given the allegations. And I won't go too far into the facts, but it does include some information about a tactical shotgun and a Chevron. I believe it's also previously stated that he has 26 cycles. The state would be opposed to any reduction in bond.
So do you have any idea what the plan is to indict? It's been 568 days. Of course, I'll include this on my email, them saying, what's up? But 568 days.
I completely understand that, Your Honor. I do not, unfortunately, before Your Honor today, I cannot purport to have any information about the status of the indictment of this case.
All right. Well, I wanted to go in the program because it's in Sonoya, and that's not Fulton County, is it?
Correct, Your Honor. That's
Which I
very
love,
far away.
but it's not Fulton County.
Right.
All right. So let's see. No drugs unless prescribed, no alcohol, no weapons. If you get admitted into the Better Way Ministries program, that's an 18-month program, you must complete it. So if you try to leave it or don't go or run away from it, sir, boom, you'll sit here till you go to trial, which will be more than 568 days. So you'll provide that address upon bonding out. That way, if you get in or you're there, we'll know. Stay away from 1217 Metropolitan Parkway and all Chevron gas stations, especially ones in Fulton County. No drugs, no alcohol, no weapons. You're going to have an ankle monitor with a 24-hour curfew, except for court, medical visits, attorney visits, participating in the program at Better Way Ministries, and employment, as long as you supply proof of employment, name of employer, schedule, and exact location you'll be working. See if I got everything. Oh, no further contact with ROBEL, last name Mohammed, and no further contact with Bobby Ali, ALI. That ankle monitor will be paid for by the county. So we've already put it down.
Is this going to be a transport order to Better Ministries, or he's going to Better Ministries once he is released from the Fulton County Jail?
We would be doing a transport order if if we can get the bond down enough where
So
the
he
bail
can make
bond
it.
will pay it. Okay.
So he'll have to go there when he gets out, or if he makes it, they'll get, she'll get me a transport order.
Okay,
All
because
right,
I
so
just
I'll-
want to say, because if I put Better Ministries on there, then they're gonna say, is he gonna be transported there or is he going upon release? So what I'll put is Ms. Bray is to submit transport order to Better Ways Ministry.
Yes, Better Way Ministry. And they do come and pick them up.
Okay,
So I'll
thanks.
have the name of the person who's coming to pick them up, when, and all of that stuff when I do the transport order.
Thank you.
All right, we'll go 4. Wait a minute, what's this one? 3. 2000 and UJR jail. 4, 2000 and UJR jail. You get them to do that, right, Miss Bray? You can work miracles.
We'll see. Every now and then they'll go slightly over 5.
All right. Well, you know how to get back here. Best of luck to you, sir. All right. All right, let's see. We got Jarvis Brown. Wave your hand. Kevin Varner. And Quavius Allen. Alshon Plain. All right. We run it. Jalen McKnight. Okay, now we're running out of names, so we're right. Here we go. Alshon Plain. That's position 6 on that February calendar that was an add-on calendar. I mean, the January calendar. 22 CP 212-215. 139 days without indictment. Armed robbery, assault, possession of a knife or a firearm during the commission of or attempt to commit certain felonies. There is no bond as of September the 10th. Pre-trial.
Judge, is it just me or does your accent seem to be thicker today? Because I'm not understanding these last names you're saying today.
Bostic, I don't have an accent.
Okay, then it's just me. In
Right.
regards to Mr. Plain, this is only prior arrest here, 2 in Louisiana with no disposition, nothing further.
Go ahead, Mr. Lang, or Mr. Cazzola, you covered it for Mr. Lang.
Yes, Your Honor. Thank you.
Tell Bostic I don't have an accent.
Your Honor, I'm gonna plead the fifth on that one. All right, Your Honor. Mr. Plain is 21 years old. He's been in Georgia for the last 2 years. He has a good address at 6522 Beaver Creek, Atlanta, Georgia, 30349, where he lives with his mother. Your Honor, he received his diploma from VNet Charter in New Orleans, Louisiana. And he's working on his CDL, his commercial driver's license, and he currently works at O'Reilly Warehouse, or at least he did at the time of his arrest. And he has a 2-year-old daughter. As mentioned, Your Honor, he does have a very limited criminal history. I understand the severity of the allegations, but they are mere allegations. And again, this with him having no history, there's no pattern that's been established here. We are asking for a bond not to exceed $30,000. Asking for $15,000 on the armed robbery, $10,000 on the ag assault, and $5,000 on the possession of a firearm.
All right. What says the state, Mr. Jordan?
Your Honor, in regards to this particular case, as one of the state's concerns is that he does have significant ties to the state of Louisiana. I understand that Attorney Cazzola has already stated that he has been in Georgia for the last 2 years. Without getting into the facts of this particular case too much, the particular vehicle that the victim was chasing after the armed robbery did occur had a Louisiana license plate that Mr. Plain allegedly was in. Your Honor, given his ties to other community and the dangerous nature of these particular charges, at this time the state would oppose bond. And we would defer to Your Honor if you are inclined to grant a bond in this case on the particular number that you would assign.
Oh, yeah, I have to. It's been 139 days. Where is he going to live, Mr. Cazzola?
Your Honor, he'd be living with his mother at 6522 Beaver Creek, Atlanta, Georgia. And Your Honor, as I understand the state's position here, but he's 21 years old. If he was 40 years old living for 2 years in Atlanta, Your Honor, might seem limited, but his adult life has only been 3 years, and 2 of those have been spent in Atlanta, Your Honor. And his mother, who he lives with, has a home here. So we would ask, it's our position that those are strong ties, and we would ask the court to set a bond as he is statutorily entitled to one.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Martin Lewis. Stay away from 3257 Main Street in Atlanta. Isn't that East Point though? Or College Park? College Park. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, work. But sir, it's not allegedly selling puppies. That's not your work. You're to no longer sell animals online. So no social media. No trying to sell pets online. So work, you have to provide the name of your employer, proof of employment, and your schedule and the exact location you'll be working. Make sure you stay at that address. Let's see. Make sure I got everything here. Who is Diamond Hamilton? Is that his mother?
That's not the name I have, Your Honor.
Okay.
But
No further contact with Diamond Hamilton, whoever that is, because that's who the car came back to. No further contact with that person. All right, so we're going to get 15, 15, and 5. 15, 15, and 5. Best of luck to you, sir. You can leave the booth.
Judge Manning, did you do a must reside at?
Yeah, that address is the address on there. Must reside at. Hold on, the page come back at 6522 Beaver Creek Trail in Atlanta, 30349.
Beaver Creek Trail.
Atlanta. It's on his booking sheet. 30349. Yes, ma'am.
30349 is not Atlanta. It's not Atlanta.
Wait a minute.
That's College Park.
Yeah, that's on the Clayton side of College Park. So stay out of Fulton County unless you're for court or to see your lawyer. Don't get gas, don't stop for lunch, do anything. Do it in Clayton County side of College Park. That's the south terminal at the airport. Stay out of Fulton County, sir. All right, do we have Jarvis Brown in here yet? Kevin Varner. I only got so many stacks of paper. Nasir Mead. All right. If I've heard your case, you can leave the booth. Position 19, Bostic, 22 CP 213165. Nasir, I hope I pronounced that right, sir. Mead. Aggravated assault, false imprisonment, battery, family violence, 107 days without indictment as of October the 14th. Pre-trial.
Nasir Mead, 8 prior arrests, 1 misdemeanor conviction, does not appear to have any felony convictions, 2 FTAs, but has an open case in DeKalb. 3 counts of armed robbery, criminal attempted felony, nothing further.
All right. Go ahead, Ms. Bray.
Yes, Your Honor. Mr. Mead is 25 years old. He has lived here in the state of Georgia for the last 23 years. All of his family is here in the state of Georgia. He has 2 children, a 3-year-old, a 1-year-old, and a baby on the way. He completed the 11th grade. Prior to his arrest, he was working in the area of demolition. That is a job that he can return to if he's able to afford bond, Your Honor. We did have this prelim not too long ago, just on January 20th. And I will need to point out to the court or bring to the court's attention that counts 4 and 5 were added, a misdemeanor terroristic threat, and count 5, I'm just not, I'll waive sounding on count 5.
Yeah, those 2 weren't on my calendar. Yeah, so you got the CWAC and the terroristic threats and acts that were added.
Right, and the terroristic threats is a misdemeanor, not a felony.
Right.
So you see what I'm
Yes, ma'am. I
talking
see it.
about?
So that's a
Okay.
CWAC case, yeah. It wasn't on my calendar, but I think the calendar may have been done before the prelim.
And we did the prelim, I want to say before Judge Dallas, and so bond wasn't addressed. And he's been in over 90 days.
107.
Yep, so he's entitled to a bond.
Yeah, this calendar was done before then, so that's why the other charges weren't added since they added the prelim. What says the state?
Your Honor, good evening. ADA Taylor for the state. I do realize it's been over 90 days. Case indicted. However, the charges are very serious. In the report, the defendant accused of choking out the victim until she fell unconscious. She tried to leave. He refused to let her leave. That's the charge. He is the father of 2 of the children with the victim. There was also allegations that he attempted to insist the victim engage in sex acts on live camera. She was, and therefore he became upset and choked her unconscious. Based on the egregiousness of the facts and his likelihood to commit additional felonies, facts, the state, while I know that the case has been unindicted, he is entitled, they would ask for a high bond, Your Honor. That would be at least 35 for the trafficking charge, 20,000 for the ag assault, 20,000 for the false imprisonment, another 20,000 for the felony. Well, I'm sorry, it's a terroristic threats charge. I will leave that amount to Your Honor, as well as the amount for the battery. But
And what about the CWAC charge?
The trafficking charge, the state would ask for a $50,000 bond, Your Honor.
Okay.
And Your Honor, I would ask for substantially less than that, because when the police were initially made contact, she didn't say a word. She was removed from the home. They spoke with Mr. Meade. They spoke to the other woman that was there in the home that when this allegedly took place, but she didn't say a word. And it wasn't until later that she makes these allegations against Mr. Meade.
Is he going to live at that Buford, Georgia address?
Thumbs up or thumbs down, Mr. Meade? Would it be the Buford, Georgia address?
Okay.
Yes.
All right.
And Your Honor, if I could just point out, I mean, the fact that she didn't speak up immediately is pretty irrelevant. Victims often don't say what's going on, especially when the defendant is in the room. I would just ask that you consider the seriousness of what was done. There was also more than one victim present in the room at the other instances of the fighting between the defendant and victim in this case.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Kira, K-I-R-R-A, Harrington, and Kennedy Jackson. Stay away from 1360 Virginia Avenue and 141 Elizabeth Lane in East Point, and stay out of Fulton County unless you're here for court or to see your lawyer, sir. Don't get gas in Fulton County. Don't get anything to eat. Don't get a flat tire. No reason. Go straight to court, straight out of there. Don't pass go, don't get $200. All right. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, work, as long as you supply the name of your employer, proof of employment, a schedule, and the exact location you'll be working. Sir, if you don't supply that to your lawyer and to the ankle monitoring company, they'll show that you're in violation of your bond condition and that you will get your bond revoked or probably sit in jail till your trial. And here it's got, I'm pretty sure he probably hasn't legitimated his children. And with some of these, I'm a little bit concerned with maybe the child. So no contact. I'm taking off the no contact, the contact for visitation for the child with a third party. I think that gets a little too shaky in there, where he may end up having to see her. So take the contact with the children off. They can handle that in family court. And if they do, we'll follow the order of the judge that hears the legitimation case. So I've got 25, 5. Wait, how about this? 25, 5 on CWAC, we'll do 40, and then the misdemeanor terroristic 3. 25, 5, 40, and 3. Best of luck to you, sir. Is that it for you, Bray? Let's see. No. All right. Yes, ma'am.
I thought it was. Is there another one?
Yeah, I think that's it. Because we're going to hear Tyrone Bolton. Tyrone Bolton. You got to wave your hand. Okay, we're going to hear that one last. So we got Jarvis Brown. We have Kevin Varner. And Quavius Allen.
Sahir Duval is in the 6 North booth.
Who is?
Sahir Duvall, and that's why I was asking, because I recognized him. We did his prelim maybe a week ago. And bond was set then.
Yeah, I could put it off, but yeah, bond was already
And I
set.
believe you sent out an email saying that.
Yeah, I took him off the counter. Sorry, sir, your bond was already set at prelim.
Judge, I'm ready on Miss Washington, but she's out of custody, and I know those usually go last, so I'm not trying to jump the line.
No, we're trying to see if, okay, let's see. Wait, let me get those. I got those.
For Mr. Brown, it looks like he's on 7 North, but I don't see anybody in that booth.
I'm looking for people to wave their hands. Jarvis Brown, wave your hand. Kevin Varner, wave your hand. And Quavius Allen. Kevin Varner. Okay, I've called your name. What have you been doing? I've called your name at least 8 times. All right. Mr. Cazzoli, your client's figured out his name. 16, Bostic. 22, CP, 213158. Kevin Varner, Bostic. 107 days without indictment, aggravated assault, cruelty in the third. $30,000 good bond as of October 13th. Pre-trial.
Only prior arrest.
All right, go ahead, Mr. Cazzoli.
Thank you, Your Honor. Mr. Varner is 38 years old. He is a lifelong Georgia resident. He has a good address. He doesn't know it, so we will make sure that we get something together before his release. He is currently on disability, Your Honor. There are some severe MH issues that were detailed pretty extensively in the warrant. Your Honor, so we're actively trying to get him some help in that department as well. We are asking for the bond to be reduced from $30,000 in half to $15,000. That will do nothing for him currently, Your Honor, but it will get him close to a number that he can afford in the future once we have some kind of treatment plan for him.
All right, what says the state?
Your Honor, the state would not be opposed to a reduction in bond. We would just ask for a total bond in the amount of $20,000 in this case, $15,000 for count 1 and $5,000 for count 2. This does involve Mr. Varner's sister. The allegation is that he struck his sister in the head with a vase. Officers noticed that the victim had blood on her neck, arms, and face when they did arrive. We did speak to the victim prior to this bond hearing. They are afraid of Mr. Varner, and by they, I mean the sister and the mother. Allegedly, this argument did start over either the sister or Mr. Varner yelling at the mother, whom is also ill. So the state would ask for a bond in the amount of $20,000, Your Honor.
All right. Mr. Cazzoli, you have an address where he'll be living? Is it going to be in Fulton County anyway? Is it going to be in Fulton County, sir? Thumbs up or thumbs down? Mr. Varner, is it going to be in Fulton County? You have to give me a thumbs up or a thumbs down. Okay. Make sure you supply that address to Mr. Cazzoli immediately, or to be released on bond, you're going to have to supply that address. No drugs unless prescribed, no alcohol, no weapons. No further contact with Tiana, Tiana-DASH, and Jaquan, Jaquan, Win, WIN. Stay away from 166 Anderson Avenue, apartment B19, Atlanta, Georgia. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, and work. You have to supply the name of your employer, place of employment, the schedule, and the exact location you're going to be working. Well, now you're shaking your head. Now you understand, right, Mr. Cazzoli? Exact location you'll be working. So we'll do 15 on count 1 and 5 on count 2. Best of luck to you, sir. You can leave the booth.
Thank you, Your Honor. I think that finally completes my business as well. May I be excused?
Yes, sir, Mr. Cazzoli.
Good
All
to
right,
see
let's
you.
see who we got here now. And Quavius Allen. Jalen McKnight. Boom. All right. As position 7 on that January the 12th add-on calendar. 22 CP 210100. 194 days without indictment. No bond as of June 24th. Man, can't believe it took this long to get here. As of June 24th. Aggravated assault, armed robbery, possession of a knife or a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Wow.
McKnight. 14 prior arrests, open case 22 CP 209573. Felony theft by shoplifting, felony obstruction 2014, firearm by convicted felon in 2016, entering auto in 2019, and ID theft 2 counts. Nothing further.
Go ahead, Ms. Gowdy.
Yes, Judge. Before the court is Mr. McKnight. He is 25 years old. He's been in custody for 194 days. We tried to address bond on this case 70 days ago when he was also statutorily entitled to a bond then, and it wasn't on the calendar. I'm not really sure why, Your Honor. But he is statutorily entitled to a bond. If released on bond, he has a good address. It's 6354 Princeton Ridge Drive in Lithonia, Georgia, zip code 358, Your Honor. He's been living in Georgia the entirety of his life with his family, his mother, his siblings, his extended family, all live here in Georgia. He was working in landscaping prior to being incarcerated in this case, Your Honor. Has high school education, attended high school here, attended college thereafter here as well, Your Honor. As it relates to the criminal history, Your Honor, I reviewed the GCIC. To my understanding, no FTAs. I saw one VOP, but that's it, Your Honor. As it relates to the risk of violence in the community, I didn't see any violence in the criminal history besides an obstruction, Your Honor, but no armed robberies or robberies, anything involving a firearm, anything of this magnitude, Your Honor, which is why it's particularly concerning to Mr. McKnight that he's being accused of these offenses. He does adamantly deny any involvement in this incident, Your Honor, and we're hoping that once we have a separate court date, we can finally subpoena his phone records to prove his alibi in this particular case, Your Honor. So I think that's how adamant Mr. McKnight is as it relates to these allegations. He's willing to submit to his phone records being submitted to the state, Your Honor, which we've discussed the risks that are involved with submitting your phone records to the state, Your Honor. But as it pertains to bond in this case, we're asking for the lowest bond possible. He does not have a preliminary hearing set for this matter, even though he's been in custody for almost 200 days at this point, Your Honor. He also has not had a prelim on the theft by shoplifting offense as well, Judge. So as it pertains to bond, we're going to ask for a cumulative bond not to exceed $15,000, Your Honor. He does not know the victim personally, Your Honor, so he's okay with the stay away. He's okay with a no further contact provision. The only caveat I would say to the stay away, Your Honor, is that his sister lives in that same apartment complex, to my understanding, Your Honor. She was living in that same apartment complex. So, Your Honor, as it relates to a stay away, if the court wants to put like 200 feet away from that particular unit, I think that's more than feasible for Mr. McKnight to abide by, Your Honor. Thank you.
All right, what says the state?
Your Honor, given Mr. McKnight's criminal history, the state would assert that he is a risk to reoffend. I have in my notes that his bond was denied on June 24th of 2022, but I understand from the proceedings that may be incorrect. Your Honor, we would assert that due to Mr. McKnight's 3 previous convictions that he is possibly looking at life without the possibility of parole on the armed robbery charge if he is convicted. Your Honor, the state would ask for a total bond in the amount of $135,000. Actually, Your Honor, I'm sorry. Once again, as I said, embarrassing myself with the math. Let me do a count by count breakdown. For count 1, the state would ask for a bond in the amount of $20,000. For count 2, the armed robbery, the state would ask for a bond in the amount of $75,000. And for counts 3 and 4, the state would ask for a bond in the amount of $5,000 for each count, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Marlon, Marlon Blackwood. Stay out of Fulton County unless you're here for court or to see your lawyer. Stay away from 320 Fairburn Road Southwest. So that means his sister could go see him, Miss Gowdy. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and work. As long as you supply the name of your employer, the place of employment, a schedule, and the exact location you're going to be working. You have to give that to Miss Gowdy. She can in turn give it to the state. Sir, you're going to have to give it to the ankle monitoring company or else they'll have that you're in violation of your bond condition and they will revoke your bond. When you come to Fulton County, you go straight to see your lawyer, straight to court. Don't get gas, don't get a flat tire, don't do anything other than go park, go in the building, leave. Don't stop for lunch. Don't do anything. No flat tire. If you're going over somewhere else, you get on 285. All right. So, excuse me. Yeah, it looks like it was no bond at first appearance. There was no bond at first appearance. All right, let's see. Aggravated assault, 20, armed robbery. Sorry, I've closed out. I want to look at one thing. Sorry, it's getting a little slow. Is there still that hold for the parole violation, Ms. Gowdy?
No, there isn't, Your Honor. I was going to bring up something else, but I'll let Your Honor address bond on this case first before I bring up my next point.
Go ahead.
So, Your Honor, also on this booking screen, there is an 18 MC 00283. It's a magistrate court case from 2018. I imagine that's how magistrate court maybe classified cases back in 2018. I'm not particularly sure, Your Honor, but to avoid running into the risk of him sitting another 70 days before this case is finally put on the calendar, I'm just asking for UJR jail on that offense.
Looking for that. So that could also be if somebody took out a warrant application. Sometimes,
Ms. Young is maybe trying to comment.
What was that? Oh, sorry. I'm in the wrong. Give me that warrant number again, Ms. Gowdy.
It was 18 MC 00283. It's on his booking screen.
I'm trying to see what kind of warrant is it.
usually mag court's MAGC.
Yeah, it's for possessions of a tool. That's kind of odd. I don't know why they did it 18. It was a magistrate warrant done. It was signed by Judge Malone. So an officer actually came in.
So it wasn't a warrant application.
It wasn't a warrant application. They actually did the warrant, and I'm not for sure. Let's see. It was taken out in 18, 19, 20, 21. Oh, it was a felony. So it has not been addressed.
They need to get him on a first appearance for that.
I go in the morning. So I'll send booking tonight, and then I'll just have him added onto the calendar in the morning for that.
Okay. So I'll do
you said 20 on the ag assault.
20 ag assault, yeah, 45 armed robbery, 5 and 5. 20, 45, 5 and 5. That ankle monitor be paid for by the county. Sir, if you've had any holds, you'll have 48 hours to have this ankle monitor placed on your ankle. If you don't have it placed on there, then it'll be a violation of your bond condition. Best of luck to you, sir.
45 and 5, 20, 45, 5 and 5.
Yes, ma'am.
Thank you. And Ms. Galley, I'll have him, I'll make sure he's on first appearance in the AM.
All right. And Quavius Allen. All right, there he is. It's 2 on the January the 12th calendar, Bostic. 22 CP 209208. And Quavius Allen, 52 days without indictment. Robbery by force, battery, substantial harm. There is a $30,000 good bond as of August the 18th. Pre-trial.
Allen and Quavius. 15 prior arrests. Open cases, 21 CP 196984, aggravated assault with a deadly weapon, firearm during simple battery, family violence, 21 CP 197107, theft by receiving stolen property and obstruction. On probation, controlled substance, fleeing and eluding. 10-3-22, 6 months confinement, 2 years, 6 months probation. Nothing further.
All right. Go ahead, Ms. Beck. I see you.
Thank you, Your Honor. I wanted to start off by pointing out that he has been in for 252 days. He has not had a preliminary hearing yet. I'm not sure how that has happened, but that's where we're at. Additionally, he has not been heard for bond since August. Right now, his bond is set at $30,000, which is something he can ill afford. And in the 252 days, the state has not indicted, and that would be, we are agreeing with the state that there has been no change in circumstance because there has been no movement by the state. Mr. Allen is 26 years old. He has celebrated a birthday while in jail. He has 2 children, a 1-year-old boy and a 7-year-old boy as well. He went through the 12th grade. Prior to his arrest, he had a job at Wendy's. He's not sure if he would be able to get that job back since it has been 252 days since he last worked there. He is a lifelong resident of Georgia. The address on file, I believe, is a good address for him. His grandmother, he lived there with his grandmother and she recently moved. I did stress to him the importance of updating the address with the court. So if that is not the correct address, I did tell him to let me know and I could file the change of address form for him. He has 2 holds currently from different counties that he is eager to go deal with. So for those reasons, we are asking for a bond not to exceed $3,000 in total so that he can be released to those holds. And while that amount is very, very small for the alleged charges, the state has had 252 days to do something about that if they were so inclined.
Is the address he's going to live in Fulton County?
Yes, Your Honor. It's Ben Hill Road, Atlanta, Georgia. And
Okay.
like I said, if that's not the correct one, he will be updating it.
All right. What says the state?
Your Honor, I'm actually familiar with Mr. Allen. I believe that I may have taken a plea of his in Judge Eaton's courtroom. I was aware of this pending CP case. We tried to get it indicted prior to Mr. Allen entering a plea to the particular case, and I apologize for the court. I do not have that case number on hand. But Your Honor, given the amount of time that it's taken to indict this particular case, the state would agree with that a bond reduction is appropriate. We would just ask that for count 1, that robbery by force, that bond be reduced to $5,000, and as to the battery, it'd be a UJR.
All right. Put that in there, Michelle. State agreed to 5,000 on count 1, UJR to the jail. So on count 2, no drugs unless prescribed, no alcohol, no weapons, no further contact with Deanshae, DEANSHAE Grant. No further contact with Essence Beatty, BEATY. Stay away from 2975 Headland Drive. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and also work. You have to supply the name of your employer, place of employment, schedule, and the exact location you're going to be working. You're going to have to supply that to the ankle monitoring company and to Ms. Beck so that she can supply that to the state. And since you've got holds, you'll have 48 hours to have that ankle monitor placed on your ankle, sir, once you get released. If you don't have it placed on within 48 hours, it'll be a violation of your bond condition. Best of luck to you, sir. You can leave the booth.
Thank you, Your Honor.
All right, Jarvis Brown.
And Your
Jarvis
Honor,
Brown. Do we
I
have
believe
Jarvis?
that concludes my business before Your Honor. May I please be excused?
Yes, sir.
Thank you, Josh.
All right.
Your
so
Honor,
we
it
got-
also concludes my business if I can also be excused.
Yes, ma'am, you can.
Thank
Thank you.
you.
You both have a good evening. All right, so
Thank
we
you.
got somebody here, we don't know who he is. William Wilson. Darius Arnold. Brandon Snowden. DeMarco Norval. Ricky Zachary. Michael London. Pearl Bennett. Dontavius Ellis. Sahir Duval. Jamarcus Wheeler. Boom. Sir, your bond was already set on the January 24th. I apologize. You sat there. We'd sent word for them not to pull you, but your bond was already set on the 24th of January. Matter of fact, I said it. So you can go ahead and leave the booth. Thank you, sir. So we just need Jarvis Brown, LT.
Okay, Your Honor. We'll reach out for him. What's his name again? Brown?
Jarvis Brown. You need the booking number?
Got a Brown.
Judge, who's in 6L? If
That's
Jarvis
one
Brown
we're
is all we
gonna-
have.
That's Bolton. That's sensitive, so we're gonna stop the stream and then hear that once we've heard this last one.
Gotcha.
Jarvis Brown, it says 5 South.
Yeah, I'll look for him. I'll give him a call over there, see if they can pull him up.
Okay.
All right. Give me just a minute, Your Honor.
Okay.
Judge, Miss
Go ahead.
Washington is on the line. Wasn't she removed?
Yeah, but he wants to modify something, I guess, on her bond. Let's see. We'll go ahead and hear that. Mr. Cho White reaches out to Mr. Brown. So this is a bond modification for Ashley Washington, 22 CP 212083. She's out on a $100,000 bond for robbery. Go ahead, Mr. Cho.
Thank you, Your Honor. Good evening, everyone. Your Honor, Miss Washington is before the court, and I have filed a bond motion at her request. Asked the court to consider a modification of bond. I will just emphasize, as the court has already said on the record, that Ms. Washington has paid $100,000 bond, so she has legitimate skin in the game. And Judge, she has been very active in her case, so she is not someone that I believe will abscond in any kind of way. Judge, we're asking that the court just modify the bond to allow her to reside in Louisiana. If the court can see, there is a change of address filed. It would be 13632 Explorers Avenue, New Orleans 70129. Per Ms. Washington's instructions, Your Honor, she's asking the court to consider a modification of the ankle monitor as well. She wanted the court to know that she's doing a great job on the ankle monitor, that she's not going to pose any threat to the community, and that she is abiding by any and all rules and regulations. So she's asking for that to be resolved or to be modified. Judge, she wanted me to let the court know that she is willing to go forward on a resolution to this case as well. Because she is not in custody, I think that there will probably be some delay at this point for that to happen. But Judge, she is someone that is willing to participate in the court process and to abide by any court conditions. Your Honor, she's the mother of 7. She's 39 years old. She cares for her 7 children. She works 2 jobs. She is an Uber driver, which she's been doing for the last 4 years. And she works for Acumen Fiscal Agency, ACUMEN, which she's been doing for 7 years. It's a full-time job. She's a high school graduate. And Your Honor, she is currently doing parenting classes and anger management classes and has been evaluated by mental health experts in Louisiana as well. For the court's knowledge, she does not know Ismail Habib, which is the listed complaining witness in this case, and she has not been and will not go back to the Best Western in Hapeville, Georgia. The allegation in this case is that a minibus, I guess is the right way to put it, or a hotel bus that's what's alleged to have been snatched ultimately in this case. Judge, we're obviously going to respect the court's ruling, but I am making this request and at Ms. Washington's instructions and trying to do the best for her that I can. I appreciate the court's time. Nothing further.
All right. Ms. Simmons?
Yes, Judge. This case on the calendar or it's just added on? Because I don't see it.
It was one of the add-ons for a bond modification. She wants to live in Louisiana, and then I'm thinking she's asked to modify the ankle monitor, which probably means she wants it off, and she bonded out November the 11th.
Oh, my instructions were that this case was taken off.
She bonded out.
Oh, I see.
So
yeah.
Oh, I see, Judge. Well, unfortunately, Judge, I did not prepare anything in response to this because of the instructions that she bonded out.
So there you go. So she's charged with robbery. She wants to go live in Louisiana.
Mm-hmm. And she wants the ankle monitor to be removed?
That's what he's asking for, yes.
Yes,
She
Ms.
just
Simmons,
bonded
and-
out and had it on in November.
Well, Judge, if she's going to leave the state, then I would ask that the ankle monitor remain so that her movements can be monitored. I'm sure there can be arrangements made for her to have an ankle monitor if she's allowed to move out of the state. And I'm not sure if defense counsel articulated exactly why she's moving out of the state. Are her children in Louisiana or wherever it is that she wants to go? I'm not clear.
Sure. Miss ADA Simmons, children are in Louisiana, and she would be residing there. That would be the best place for her. It'd be very far away from Ismail Habib and very far away from the Best Western in Hapeville, Georgia. We certainly understand the state's position and respect that completely. I will just emphasize again that this is not a $1,000 bond. This is a $100,000 bond. And so Miss Washington has been very active in communications with her defense attorney about the instructions she's given to me. So I appreciate everyone's time.
All right, Ms. Simmons.
Oh, yes, Judge.
Is that just your position?
Yes,
It's fine
Judge.
if she goes, but leave the ankle monitor on.
Yes, Judge.
All right. So that's fine that she could go put in that change of address, but she'll have to leave the ankle monitor on. But Mr. Cho, if she's doing well and there's no only because it's been on 2 months. I mean, if you come back later, there's still a chance to get it removed, Miss Washington. But yes, you could go ahead and go. Do you have an idea when you're going to leave for New Orleans, Miss Washington?
Yes, ma'am.
When
What did
do
you
you
say?
when do you plan on leaving for New Orleans?
I currently live in Louisiana, Your Honor. I never resided in Georgia. I was residing with my sister, and I don't have any housing set up for me there. So I had to come back to my.
This is kind of a beg forgiveness.
Judge, to be
mean,
candid with the court, she did. If I interrupted, I apologize. It was inadvertent. She did file a change of address, which was done on November 16th, 2022. It appears in Odyssey. 13632 Explorers Avenue, New Orleans, Louisiana 70129.
All right, let's see.
It is an Odyssey. So
So, I mean, that's fine. You can stay there, man, but just keep the ankle monitor on. And I mean, if you're doing all that you're doing, I'm sure you'll keep doing, then Mr. Cho could, petition to have your ankle monitor removed because I have removed some. Let me see what kind of. All right. So right now, though, there is a 6 p.m. to 6 a.m. curfew. You have children. And it only gives you work, medical, and legal. Do you take your children to school? I mean, I want to make this so that it works for you. So if you take your kids to school, this only allows for work, medical, and legal. So does that curfew work?
No, it does not, Your Honor. And I have other legal issues that I'm trying to get resolved at this time. And I'm afraid that with an ankle monitor on, it puts me in violation of my current bond modifications. And I'm doing well. I'm abiding by the rules. I paid $100,000 bond. I'm trying to stay with my anger management classes. I've got reevaluated. I'm doing parenting classes, and I'm just asking for it to be removed at this time because it will be certainly helpful for me. And I don't want to get in any more trouble if some of these other cases go another way, and then I'll have a violation of an ankle monitor, and it just seems like I'm running into these problems as I'm trying to iron out my legal issues.
So there's the one option, Mr. Cho, that that GPS monitoring watch just looks like a smartwatch. Have you seen those, Mr. Cho?
Kind of.
You haven't seen those, so it doesn't necessarily look like, obviously, like you walk around with an ankle monitor on, but it's it looks like it looks like a smartwatch, like just a big men's heavy smartwatch. So then that's not able, but I don't think, Ms. Gass, I don't think they've gotten approved as a vendor though, have they?
Not as of yet.
See that, I mean, then that would, nobody would know that was an ankle monitor company. I don't know what else they have to do unless they want to try to give it to us free so we could try it out. Mr. Cho, I'll be glad to. On my desk, I got their contact info.
Judge, I hear you're on YouTube, so you could get an endorsement deal going for us.
What's their name? You remember it? Let me see. Ms. Gass, I think I have their email or contact name for Mr. Cho. I'll send it to them. And if you could get them to.
I have their card too, so I can send it out to the district. Well, who should I send it to?
Probably I guess Mr. Cho, so he could call and see if they'll, and Mr. Cho can report back how it works.
Okay, that'll work.
So you got to work it that way, Mr. Cho, because you got somebody who, which I don't doubt you say, buying by all the bond conditions. And if you could talk to them, there's a man and a lady. And just tell them that you talked to me and Miss Gaston and Miss Lewis, and we said we'd like to try one out while he's still trying to get on there, but you're going to ask it to be it's an indigent client. You're asking for something that's an indigent fee, which is $0 because he's not a volunteer. I mean, he's not a vendor yet. But I think that'd be a great way for us to see how it works.
I can definitely try, Your Honor, if that will help Miss Washington and what she's requesting. I'll be in court tomorrow in the morning and then 1 o'clock again, so I'll work on it as soon as I can.
Yeah, Miss Gaston will send you that info too. Miss Washington, so 9 p.m. Can you get everything you need to do by 9 p.m.?
I'm working 2 jobs, so my schedule is kind of,
Okay, so you got to give me a time at night, 11 p.m.
Yes, ma'am.
All right, 11 p.m. and you can leave at 6 a.m. So if you're taking your kids to school, so we'll put work, medical, school, children, caring for the children, and
parenting and anger management.
Any classes that you have to do, right, Mr. Cho? So any classes, parenting, anger management, or anything that's you're trying to do that Mr. Cho, and all he's got to do is just give information to Mr. Cho. Hey, I've got a parenting class, and let the ankle monitoring company know. I got a parenting class, and it's from this. So parenting class, ankle management, anything else?
Yes, Your Honor, just off the record on that, can I ask if Mr. Cho is able to file another motion for it to be removed after this? What's your time frame on that, if I might ask?
If I could tell you, then I'd be prejudging it. So I can't tell you, but I'm hoping he could get the other thing. So Mr. Cho kind of knows me, so you can leave at 6 a.m. and we'll put anything in there having to do with your children, activities, school, and then basic life necessities. Like you go to the grocery store and things like that. You just have to let the ankle monitoring company know that you're there. Okay.
Yes, ma'am.
All right, Ms. Washington, I'm on your side. Looks like you're doing great.
Okay, thank you.
Mr. Cho, just amend that and get it to me.
Yes, Judge, I will.
All right. Thank you, Ms. Washington.
Thank you. Thank you, Mr. Cho.
Did we find Jarvis Brown?
Your Honor, may I be excused?
Yes, sir, Mr. Cho.
Thank you. Have a great night, everyone.
You too.
Your Honor, Jarvis Brown has been moved to 7 North. We're trying to get in contact with the floor now to see if we can get him to the booth.
Oh, okay. I guess we need to invite the booth, right?
Yeah, I've already talked to Ms. Robinson.
7 North is
Judge, we're opening the booth right now.
Okay. So we can remove this.
What happened to Carl Bennett?
No, okay, so the ones that I called out were removed. William Williams, you got that list, right?
No, I got the list, but Carl Bennett wasn't on the list.
Yes, sir. Can you
I scanned all of the papers. So William Williamson, Darius Adams, Ashley Washington, Brandon Snowden, DeMarco Norville, Ricky Zachary, Michael London, Carl Bennett, because he had a bond hearing on January 24th.
Okay, thank you.
Don Tavius Ellis.
Oh, I got everybody else. I was just missing him.
All right.
Carl Bennett, bond 124.
Okay. I'm sure you already got some in the queue, so I can go ahead and start signing, right?
I have like 20 something in the queue. Yay, yay.
Just waiting on me.
And Bostic to catch up with the positions.
Bostic saying I have an accent. She hears with an accent.
Where is she at? Oh, I see her. I see her.
I'm here somewhere, so
Here she comes.
Bostic.
what are y'all messing up right now?
Right now, we're waiting on Mr. Jarvis Brown. Ms. Sarfarazzi, is he still gonna live in Clarkston?
No, Your Honor, I have a new address for him in Smyrna.
Okay.
Who we waiting on? I forget.
Jarvis Brown.
So you should have two more, Bostic. Two more.
Jarvis and
I
Tyrone.
got Jarvis. Who's the other?
Tyrone Bolton.
I think I got him. I got him.
Yeah, let's see, Wax. We're gonna handle that when I'll stop the stream, and then the other places are removed.
I just don't be. I didn't scroll down enough to get them to. I don't know.
No
I think
offense,
my
Ms.
brain be
Simmons.
like, that's enough. I'm not going any further.
Y'all need to ask Miss Amjadi them is that I read all these warrants and stuff beforehand, so. Is Mr. White back? Miss Simmons,
I'm sorry, Judge.
is Mr. White back?
Mr. White.
Yes.
I'm not
Thomas?
sure. I'm sorry.
You don't know Thomas White?
No, Judge.
Oh, okay. Well, I was just
White. Oh, I'm sorry. He'll be back next week.
All right, good. Just something we asked about. All right. Jarvis Brown. All right. His position 6, Bostic, 22 CP 213041. Jarvis Brown, 110 days without indictment, aggravated assault, possession of cocaine, no bond as of October the 10th. Pre-trial.
Jarvis Brown. Yeah, 17 prior arrests, prior burglary, open case, and DeKalb, armed robbery, aggravated assault, firearm, during firearm by. He's on probation, DeKalb, also for aggravated assault, sentenced in 09, a 20-year sentence, 10 years, confinement, 10 years probation. Nothing further.
All right, go ahead, Ms. Safarasi.
Thank you. Thank you, Your Honor. Mr. Brown has been in custody for 110 days without indictment or without a preliminary hearing. The prelim was originally scheduled for January 19th. The officer did fail to appear, and so I believe it was Judge Dallas that reset that hearing for February 3rd. So we look forward to have our preliminary hearing on February 3rd. Mr. Brown maintains his innocence and claims of self-defense in this case, just for the record, Your Honor.
Okay.
He has been in custody, as you said, Your Honor, since October 22nd on this no bond. We do have a good address for him, which is his sister's house, and that address is 2200 Atlanta Road Southeast, an apartment. It's an apartment, Your Honor, and that's in Smyrna, Georgia. And I will be filing a change of address, Your Honor, to just update the system. We are also, for the record, I've already done the social worker request, and our social worker is trying to get him into a program. Due to the nature of the charges, my understanding is that sometimes they're harder to get into when you have certain charges. So we are facing that, but nonetheless, we are still trying to get him into a program to help some of his issues, Your Honor. A little bit about my client. He is 32 years old. He's been in Georgia about 15 years now, Your Honor. He worked for UPS as a driver, and he had that job for about 3 years before he got incarcerated. And he also
okay, I think we're done. They're in the middle of shift change.
Go ahead.
And then he also had a side job as doing landscaping, Your Honor. He does have his sister, like I said, in the area that was her address that he would be staying at. So, Your Honor, we are asking for you to set bond in this case. He is legally entitled to bond in this case. But we are asking you to set $15,000 total, $10,000 on the aggravated assault, and then $5,000 on the possession of cocaine. And Your Honor, we just stand behind that the state could either move forward with any charges if they have any concerns about Mr. Brown. They could just indict his case and move forward so we can go through that court process that we all have those constitutional rights. Thank you.
All right, Ms. Simmons.
Yes, Judge. The defendant was held in no bond status when he came before the court previously, and the reasoning of the judge at that time was that he was posed a significant likelihood to reoffend and also pose a danger to the community. That is based on the fact that while he had an aggravated assault case pending in the cab, he allegedly committed this new aggravated assault offense, and he had a previous conviction for aggravated assault, which indicates that the defendant does have a propensity towards committing these kinds of violent offenses. And as I said, Judge, he has a pending ag assault and has now picked up another aggravated assault where he is charged with, based on the indictment, Judge, he allegedly stabbed the victim in the head and face, leaving serious injury and a serious loss of blood. Having spoken to the victim, Your Honor, they are concerned about the defendant's release because they feel that he is dangerous and would be a danger to the community and to the victim himself. That being said, Judge, he is entitled to a bond, and so the state, if the court is minded to give him a bond on the aggravated assault charge, the state would ask for a bond of $25,000, and on the possession of cocaine charge, the state would ask for a bond of $10,000 for a total of $35,000.
All right, it looks like we have somebody here. The victim's name is Anthony Rucker, and there's a Sharika Rucker. Is that Mr. Rucker?
Yes.
Is Mr. Rucker that? Can you turn your camera on?
Oh, yes, ma'am. Oh, I'm going to a light. Okay.
Is Mr. Rucker there, ma'am?
No, ma'am. He just got out the hospital. My brother suffered from epilepsy, and he is really, really beat up from
hold on one second.
Having a seizure.
Hold on one second. You raise your right hand. You swear a firm testimony you're going to give is truth, whole truth, nothing but the truth?
Yes, ma'am, I do.
Right. So you're his wife or his sister?
I'm his sister.
Okay. He's just still in the hospital because of this event?
No, ma'am. He just had a seizure.
Okay. Well, I hope he gets better. Does he live with you?
No, he lives with my mom.
Do you know, I mean, obviously he's recovering from that. Do you know if he's told you anything about like bond or what his opinion is or anything like that?
Well, he actually feared for his life. He was actually in the hospital bed from a seizure and went down. The paramedics took him in that night. And 2 days later, he was still in the hospital. The defendant came in and cut him while sleeping in his face and in his head with a box cutter.
Okay. All right. So if you tell your brother that, statutorily, so by law, he's been in more than 90 days without being.
No, the defendant is not my brother, the victim.
No, I said tell your brother that the defendant has been in jail more than 90 days. So by law, I have to give him a bond. Okay. So I can't keep him in there with no bond if they haven't indicted him. So I do have to give him a bond. All right. So here's what I'm going to do. No drugs unless prescribed, no alcohol, no weapons, no further contact with Anthony Rucker. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. Don't come for gas. Don't come for lunch. Don't get a flat tire in Fulton County. You live in Smyrna. Stay on 285 and don't let it go anywhere. Don't run out of gas on 285 if you're going somewhere. Stay out of Fulton County, period. You know, that ankle monitor is going to be paid for by the county with a 24-hour curfew. You can leave for court, lawyer, medical, at work if you supply the name of your employer, place of employment with the proof, schedule, and the exact location you'll be working. And stay away from 550 Peachtree Street, which should be easy because you're going to have to stay out of Fulton County. I'm going to get 35,000 on ag assault and 10 on the possession of cocaine. Best of luck to you, sir. You can leave the booth. So those are the conditions, man. He'll be fitted with an ankle monitor. They're monitoring 24 hours a day, and he's got the $45,000 good bond, which means he can put up property or somebody can pay, I think it's 12% cash to get him out.
Okay.
Okay?
Yes, ma'am.
Thank you so much, ma'am. And I hope your brother recovers.
Thank you.
All right.
Your Honor, may I be excused? That completes my business for tonight.
Yes, ma'am. Thank you.
Thank you.
All right. You go over here and stop the stream. So who is we got a couple people in here to